applications for CCTV in the bank. The state being number 238885, evidence for fiscal paper for the year, Complementarity reward, Panama Predicting Bank in default, Deadline Behavior, Ratification, and the 30th Standard for Legacy Funds, Reference Primary Paper 25, Submitted Paper 10, Covering the Exchange Rate, and Submitted Panama. And the other cases is 0.20483, the total payment information that was not identified, the welcome on the forest, Dr. William and Farming, and other finance CGI, procedural review, the data information of order, the number of remedies, and automatic review, measure to destroy evidence, measure to spread the following hearing, repower of efficacy, contact reward elements, and instructing again, purchase, after the certification account, represented by Veto and the interviewer. The statement of prerogatives, represented by Veto and ratification account, and the permanent measure of the public representatives to the regulations, represented by Veto together with reward. There 22 August 2018, petitioner senators respectfully move that they be given until the next session of the House of Congress within which to decide an appropriate course of action on the issue of their representation in these proceedings. Petitioners senators reserve the right to submit any pleadings or motions in response to any question or matter raised in these proceedings in relation to the above manifestation. Thank you, Your Honors. Your work is inconsistent with our judicial procedure to solve the question. Thank you so much, Your Honor. You can be excused. The secretaries will be there.
You may proceed, Counsel.
Thank you, Your Honors. May it please the Court. Good afternoon, Your Honors. I am Attorney Romel Regalado Bagaras, Counsel for Petitioners in Philippine Coalition for the International Criminal Court versus Executive Secretary, GR number 239483. With me are my colleagues, Attorney Gilbert Teruel Andres and Attorney Ray Paulo Santiago. Your Honors, I will argue that the unilateral withdrawal by the President from the Rome Statute is invalid because it is unconstitutional. Meanwhile, Attorney Andres will argue why such withdrawal cuts or erases the protections provided by international law to citizens for violations of their fundamental rights. Finally, Your Honor, Attorney Santiago will provide the jurisdictional and procedural bona fides of the petition. Unless the Court has initial observations, may I now proceed with my presentation. May it please the Court. Thank you, Your Honors. Your Honors, we have three submissions for our case in regard to the validity of the unilateral withdrawal by the President from the Rome Statute. Our first submission: the Philippine unilateral withdrawal from the Rome Statute by note verbal is not valid, binding, and effectual from the point of view of constitutional law. And we have three arguments for the first submission, Your Honor. Our first argument: it is invalid because it bypasses the two-step procedure taken by the government for Philippine membership in the International Criminal Court. To recall, Your Honor, one, the government through the Senate acceded to the Rome Statute. Two, upon accession, the executive through the DFA deposited the notice of accession with the UN Secretary General pursuant to Article 125, Paragraph 2 of the Rome Statute. Without Senate accession, the government could not go directly to the UN Secretary General to make a valid deposit of the notice of accession. Our second argument: by the acta contraire principle, accession and withdrawal are parallel actions requiring parallel procedures. A deaf dance involving a pair of dancing partners, in this case, the executive and the legislative. Pimentel, cited by the respondents, in fact sees this as part of the checks and balances in government. If there is no valid accession to the treaty without Senate concurrence, neither is there valid withdrawal from the same treaty without the Senate also concurring in it. Our last argument for this first submission, thus what we have, Your Honors, is a discordant result. The unilateral withdrawal forces constitutional and legal acts that the executive has no power to effect on its own. Which now leads me, Your Honors, to my second submission. The executive cannot unilaterally withdraw from a treaty without violating the Constitution. Three arguments, likewise, Your Honors. First, treaties embody and exhibit a shared responsibility between the two branches of government concerned. Section 21, Article 7 of the 87 Charter is clear. It is the vote of 2/3 of the Senate that give valid and binding effect to the treaty as Philippine law. A treaty already transformed into Philippine law cannot be undone by a one-sided act of the President. Only the Senate can undo its own act unless it is voided by the courts. In fact, as we speak, Your Honors, Senate Resolution 546 stands as valid law pursuant to the treaty clause. Our last argument for our second submission, Your Honor, or rather our second argument for our second submission, this shared responsibility is also displayed in the distinctions between treaty and executive agreement. A treaty requires Senate concurrence, not so for an executive agreement, as it is only a continuation of an existing policy or an extant treaty. The Rome Statute is a treaty, as admitted by both parties. Unlike an executive agreement, the Rome Statute is subject to constitutional procedures for accession and withdrawal. Finally, our last argument. Under the Constitution, the President is the chief enforcer of laws enacted by Congress. The unilateral withdrawal is interference with Congress in the latter's performance of its duties and powers. Such withdrawals, therefore, is a violation of the doctrine of separation of powers, a transgression of the sphere of sovereignty of the Senate. Your Honors, we now go to our last submission. Even assuming that treaty commitments may be unilaterally withdrawn, the executive does not have any cogent factor or legal basis for the withdrawal other than the President's whimsical and arbitrary decision. Three arguments. Our first arguments. Respondents admit that the relevant core crimes penalized in the Rome Statute have been reproduced in the Philippine IHL Act, RA 9851. In particular, genocide, war crimes, and crimes against humanity, punished in Articles 6, 8, and 9 of the law. This is pursuant to the principle of complementarity, which this court in Bayamuna versus Rumolo has ruled to be a key principle of the Rome Statute, binding on all states parties, including the Philippines. The preliminary examination launched on the Philippine situation by the ICC prosecutor is part and parcel of complementarity. During such examination, the ICC prosecutor coordinates with national authorities to ensure, to quote leading cases, the progressive, concrete, and tangible steps taken against impunity. Failing that, the aut dedere aut judicare principle sets in. Unfortunately, Your Honors, we abruptly and irrationally withdrew from the Rome Statute even before this process could proceed in earnest. Our last argument, Your Honor, for our third submission. Treaty obligations under the Rome Statute are recognized limits to sovereignty. This court has held so in so many cases leading all the way back to the military basis agreement. This is the doctrine of auto-limitation applied pursuant to constitutional and international legal obligations to provide effective remedies to citizens for violations of their fundamental rights. Your Honors, to recall, our submission is that the unilateral withdrawal by the President from the Rome Statute is invalid, ineffectual, and void because 1, it is contrary to the treaty clause of the Constitution, 2, it violates the separation of powers, and 3, it is arbitrary and whimsical, devoid of any legal and factual basis. Your Honors, Attorney Andres will now argue why such withdrawal violates the aut dedere aut judicare principle, erasing citizens' protections under international law. Thank you, Your Honors. May it please the Court.
Petitioner may now start with his presentation.
May it please the Court. Your Honors, I am Attorney Gilbert Teruel Andres, and I will address issue letter D, whether or not the Philippines' withdrawal from the Rome Statute will diminish the Filipino people's protection under international law. Even if it does, whether or not this is a justiciable question. Your Honors, petitioners respectfully contend that the Philippines' withdrawal from the Rome Statute will not only diminish, but will abolish the Filipino people's protection under international law. And we argue this, Your Honor, using our 4 submissions. Our 4 submissions, Your Honor, will start with our first submission, that the Philippines' withdrawal from the Rome Statute will abolish the Filipino people's parallel means of enforcing their right to effective remedies against international crimes and gross human rights violations. Your Honor, the subject crimes of the Rome Statute are not mere ordinary crimes. These are crimes of most serious concern to the international community. In fact, these are international crimes, such as war crimes, genocide, crimes against humanity. In fact, under international law, the prohibition against these international crimes, our jus cogens norms, are subject to universal jurisdiction, are imprescriptible, invulnerable to the defense of sovereign immunity, and subject to the aut dedere, aut judicari principle. Hence, Your Honor, due to the gravity of the crimes that are the subject of the Rome Statute, there is a need for the right to effective remedies against these international crimes. And this right to effective remedies is provided in various human rights instruments, such as Article 2, Paragraph 3 of the International Covenant on Civil and Political Rights, of which we are a state party to. Moreover, Your Honor, since the subject crimes of the Rome Statute are most serious crimes of concern to the international community, there is a need for a parallel means of enforcing the right to effective remedies against these international crimes. And the International Criminal Tribunal is precisely that parallel means of enforcing that right against this gross human rights violation. This is provided for in the second paragraph of Section 17 of RA 9851, which provides, in the interests of justice, the relevant Philippine authorities may dispense with the investigation or prosecution of a crime punishable under this act if another court or international tribunal is already conducting the investigation or undertaking the prosecution of such crime. Moreover, Your Honor, in fact, the ICC Appeals Chamber on the case of admissibility in Prosecutor versus Jermaine Katanga has stated that if a state party does not prosecute or does not investigate international crimes under its jurisdiction, then that case is deemed admissible before the ICC. Which leads us to our second submission. The Philippines' withdrawal from the Rome Statute will abolish the Filipino people's parallel means of enforcing their right to effective remedies against international crimes committed either by state forces and or by armed groups. Your Honors, the Rome Statute gives criminal liability both to state forces and to armed groups. Third, Your Honor, since what are involved here are rights to effective remedies against international crimes, this is clearly within the judicial power of this court, which includes the duty to settle actual controversies involving rights which are legally demandable and enforceable. Lastly, Your Honor, this is clearly a justiciable question. For our withdrawal from the Rome Statute without Senate concurrence will abolish the Filipino people's parallel means to enforcing their right to effective remedies against international crimes and gross human rights violation. Consequently, that unilateral withdrawal was done with grave abuse of discretion, amounting to lack or excess of jurisdiction on the part of the Chief Executive, and this is within the judicial power of this court, precisely the expanded certiorari jurisdiction of the Honorable Court. With that, Your Honor, I will now cede the podium to my co-counsel, Attorney Ray Paulo Santiago. May it please the Court.
You may proceed. Attorney Santiago.
Good afternoon, Your Honors. I have 3 submissions for the consideration of this Honorable Court regarding the procedural matters. For my first submission, the present petition is an exception to the requirement of timeliness in certiorari proceedings, as the executive action in question is a continuing violation of the Constitution. It is the duty of this Honorable Court, based on its power of judicial review, to declare that an act of a co-equal branch as void if it violates the Constitution. An unconstitutional action can never ripen into a valid one. Thus, in Francisco versus House of Representatives, this Honorable Court held that judicial review is indeed an integral component of the delicate system of checks and balances which forms the bedrock of our republican form of government and ensures that its vast powers are utilized only for the benefit of the people for which it serves. The transcendental issue of the present petitions, which is also a case of first impression, waives any technicalities there may be. My second submission is that the petition does not violate the hierarchy of courts. In the case of Southern Luzon Drug Corporation versus DSWD, this Honorable Court clarified that the judicial hierarchy of courts generally applies to cases involving warring factual allegations. Its strict application is not necessary when the cases brought before the appellate courts do not involve factual but legal questions. This principle may also be set aside for special and important reasons, such as when dictated by public welfare and the advancement of public policy, or demanded by the broader interest of justice, such as this present case. For my third and final submission, petitioner Philippine Coalition for the ICC and the individual petitioners have legal standing. The cases of SJS versus DDB, Kilos Bayan versus Kingona, Association of Medical Clinics for Overseas Workers versus GCC-approved Medical Centers Association, among other similar cases, are instructive. In the said cases, individual petitioners were either joined by or were filed by non-traditional plaintiffs or petitioners, which are non-governmental organizations. Verily, this Honorable Court held that the rule on standing is a matter of procedure. It can be relaxed for non-traditional plaintiffs when the public interest so requires, such as when the matter is of transcendental importance, of overarching significance to society, or of paramount public interest. In line with the liberal policy on locus standi, even association of planters and non-profit civic organizations were allowed to initiate and prosecute actions before this Honorable Court to question the constitutionality or validity of acts, decisions, rulings, or orders of various government agencies or instrumentalities. The relaxation of standing likewise has been achieved through the application of the transcendental importance doctrine. It relaxes the standing requirement, but also immediate access to this court is allowed. It is also worth emphasizing that the Universal Declaration of Human Rights, which is customary international law often cited by this Honorable Court in landmark decisions, tasks all organs of society to promote and protect human rights. The PCICC has consistently campaigned for universal justice against impunity. It has advocated for and worked with the Philippine government for the ratification of the Rome Statute for the ICC. It is therefore invested, together with the individual petitioners, in ensuring that the protection afforded to everyone in the Philippines, especially its citizens, against the gravest crimes will not be whimsically, arbitrarily, and capriciously taken away by a unilateral executive act. Thank you very much, Your Honors.
The court will now proceed with the interpellation of the counsel. Who would like to start? Yes, Justice Leonen.
Attorney Santiago, please. You are a party to the case.
Yes, Your Honor.
What is your standing?
Your Honor, my standing is as a citizen of the Philippines, Your Honor, and also as a taxpayer, Your Honor.
So for constitutional issues, is it your position that any citizen may file
Yes, Your Honor.
constitutional suit?
Yes, Your Honor, it is
There
my...
are no qualifications?
In this regard, Your Honor, any citizen may file, Your Honor, considering that the role of the Rome Statute on the ICC, Your Honor, is that it gives...
There is a later
Protection.
case by the Court and Bank, the Provincial Bus Operators Association versus DOTC, where this court again clarified the requirements for justiciability. And one of them is, of course, the central to it is the actual case,
Yes.
and that the actual case must be argued by a person that is substantially and directly injured by the violation that is part of the actual controversy. So what is your injury?
For
What is
me,
your legal injury? Are you summarily disappeared?
no, Your Honor.
You're here, right?
Yes, Your
Are you
Honor.
under any kind of threat?
No, Your Honor.
Do you speak for others who are under some kind of threat which is covered by the Rome Statute?
Yes, Your Honor.
And not as counsel, but as a party, correct?
As a party, yes, Your Honor.
So the reason why in constitutional cases the requirement is for locus standi that it must be the party that has actual injury is so that the party can choose what kinds of claims and defenses they can raise, correct?
That's correct, Your Honor.
Yes, and therefore, because they are the actual parties injured, there may be certain claims and defenses which, owing to their particular circumstances, they may not want to raise, correct?
Yes, Your Honor.
And because they are the ones that will be injured, actually, substantially, and directly, therefore, the court gives them the privilege to be able to be the ones to raise it, not some other third party. Is that not correct?
Yes, Your Honor.
And by acting for, you claim that you are a party, but you are not injured.
Yes, Your Honor.
Aren't you raising theoretical questions for those who are injured or will be injured?
If I may, Your Honor, our reason is twofold, Your Honor. First is that we are questioning the withdrawal of the Philippines from the ICC.
Yes, that's the substantive question. I'm looking at your locus standi. Because your petition enumerates advocates
Yes,
for
Your Honor.
human rights, who I deeply respect.
Yes, Your Honor.
Having been and still am, because it's in the Constitution, all of us are advocates of human rights, supposedly, correct?
Yes, Your Honor.
Yes, but in terms of standing, in order to narrow the constitutional issues, and so that the rights of actually injured parties are not put in jeopardy by others who simply want to advocate. The constitutional doctrine now is that principally it must be shown that there is a personal, substantial, and direct injury, correct?
Yes, Your Honor.
Yes, even though it is a public right.
Yes, Your
correct?
Honor.
Because public rights are of different kinds, right? There
Yes,
are
Your Honor.
public rights where there are corresponding duties, and the breach of the right duty correlative must be very specific, correct?
Yes, Your
So
Honor.
what duty, what right of yours has been actually, directly, personally, substantially violated?
For my right, Your Honor, I would have to
Are
concede.
you a senator of the Republic?
No, Your Honor.
So none of your prerogatives have been touched, correct?
No, Your Honor.
Yes. So what's your standing again?
For my standing, Your Honor, I have no direct injury as of yet, Your Honor. But I would have to appeal to this honorable court, Your Honor, that the withdrawal has a 1-year period based on the Rome Statute, Your Honor. And with this argument, Your Honor, even though I have not been
Yes, that's
directly
substantive
injured, Your
argument,
Honor,
But what's your injury?
this is it, Your Honor, because I have no,
You see,
because
you
of
can
the,
speak for mammals, you can speak for the public in general, but this court empowers
yes, Your Honor.
those who have been injured to get their own counsel and appear and advise their counsel. Hanggang dito lang yung argument natin, ha?
Yes,
Huwag
Your
mong
Honor.
gagawin masyadong broad.
Yes,
Kasi
Your
kung
Honor.
masyadong broad, baka matamaan din ako. So, in order to specify the constitutional issues, as a function of what this court is, that is, we are not advisory in nature. We
Yes, sir.
want to zero in and with laser precision be able to look at the actual issues and the defenses? Or is this case premature?
With all due respect, Your Honor, it is not premature, Your
Has
Honor.
there been a violation of the of genocide? Has genocide happened?
Not yet, Your Honor.
Are there crimes against humanity that you have experienced?
This one is being considered at the
Have you
moment.
experienced a crime against humanity yourself? Are you in that situation?
I have not experienced it, but I have witnessed it, Your Honor.
No, you. Of course, everybody has witnessed it.
Yes, Your Honor.
So long as there is CNN, there is, I need to mention all the media outfits, baka magalit sa akin, GMA, ABS-CBN, whatever, Rappler, etc. Correct?
Yes,
So
Your
all
Honor.
of us have witnessed it, but have you experienced it yourself?
I have-
Crimes
I have,
against humanity, no? What about
yes, Your Honor.
aggression?
No, Your Honor.
Not yet. Okay, so in any case, therefore, there is no direct injury on your part.
I would have to concede that there is no direct injury to my part,
Among
Your Honor.
those that are in the petition, are there personalities that have experienced direct injury?
No, Your Honor.
This organization, the Philippine
Coalition for the
Coalition
International
for-
Criminal Court, Your
Yes.
Honor.
Does it have human rights?
The organization
Does
itself,
a
not
corporation, in your view, have human rights?
human rights, Your Honor.
Is it incorporated?
It is incorporated,
It's a
Your
fictitious
Honor.
person, correct?
Yes, Your
Are you
Honor.
now taking the stand because you enumerated it as a petitioner?
Yes, Your
Are
Honor.
you taking the stand that that too, that corporation has human rights which should be protected by this court?
No, Your Honor.
So it cannot have standing too.
Well, it has advocacies, Your
Can it
Honor.
suffer genocide?
It has not, Your
Can it
Honor.
suffer crimes against humanity?
No, Your Honor.
Can it suffer war crimes?
No, Your
Can
Honor.
it suffer aggression?
No, Your Honor.
No, it's a corporation. Correct?
Yes, Your Honor.
Yet it's your lead petitioner.
Yes, Your
So
Honor.
there is no standing too.
With all due respect, Your Honor, because
It's
of
an advocate, correct?
it is an advocate, Your
So,
Honor,
Are you
against
saying
impunity,
that
Your
any
Honor.
advocate can bring a case raising constitutional issues with the Supreme Court and
It,
ask the court to give an advisory opinion because they are not actually injured?
well, it depends on the factual circumstances, Your Honor.
Okay,
And
let's go to some of the other things. What form did the withdrawal from the Rome Statute? I will just short abbreviate the
Yes, Your
title
Honor.
of the treaty as the Rome Statute. What form did that withdrawal take?
it was a letter submitted by the UN Permanent Representative
Has it
of the
already
Philippines.
been communicated?
It has been communicated to the UN Secretary General,
In
Your Honor.
accordance with the Rome Statute,
Yes, Your Honor.
is that already valid and binding on the International Criminal Court?
It is considered, Your Honor, and it will become effective 1 year from the date of submission, Your Honor.
Okay, so it's done.
Yes, Your Honor.
The submission has been done.
Yes, Your Honor.
So you're asking for a writ of mandamus for this court to compel a co-equal organ of government, the President. A writ of mandamus, correct?
Yes, Your Honor.
By the way, your respondents here are the Secretary of Foreign Affairs, correct?
Secretary of Foreign Affairs. Yes,
But
Your
the
Honor.
Secretary of Foreign Affairs, if we issue a writ of mandamus to him, he will say he is not the entity that is involved, correct?
He is, Your Honor, because
His alter ego, right?
he is the
takes
alter ego of the
instructions from
President.
somebody,
Yes,
correct?
Your Honor.
Who is not a party to this case.
Yes, Your Honor.
Yes. In effect, are you suing the President?
We are suing, in effect, the Republic of the Philippines, represented by the President.
It
But
is not
since
in
the
your
President, according to the decisions of this honorable court, is immune from suit, Your Honor.
Because if you sue the
we are-
Republic of the Philippines, it includes this court.
Yes, Your Honor.
You're suing this court.
No, Your Honor.
That's your position.
I stand corrected, Your Honor. It is the executive branch.
The
Your
executive
Honor.
branch.
Yes,
Okay.
Your Honor.
You want this court to issue a writ of mandamus as a matter of ministerial duty to the President to withdraw the communication it made to the International Criminal Court. Is that correct?
That's correct, Your Honor.
Can the court do that under our constitutional order?
Your Honor, if the court can declare void the action of
Yes,
the President,
declaring
Your Honor.
void is one thing. but issuing a writ of mandamus to a co-equal branch of government on the basis of the interpretation that there is a ministerial duty to withdraw.
If it's void, Your Honor, our stand is that it should be withdrawn by the withdrawal should be withdrawn by the President,
Okay.
Your Honor.
If the withdrawal has already taken effect, will it mean that to withdraw the withdrawal, follow me, to withdraw the withdrawal requires another signing by the President and accession by a concurrence by the Senate? Because we're already withdrawn from the treaty, correct?
Yes, Your Honor.
And the only thing is that it takes effect only after 1 year, correct?
Yes, Your Honor.
But as far as the community, now part of the International Criminal Court, is concerned, the Philippines has withdrawn, correct?
That's correct, Your Honor.
To rejoin, it is not to withdraw the withdrawal,
Yes, Your Honor.
but it is to sign
accede.
again
Yes, Your Honor.
and accede, correct?
Yes, Your Honor.
So you are too late.
That is the reason why, Your Honor, we are bringing this before this honorable court,
Yes,
Your
but
Honor.
it has
And
already been communicated.
that's correct, Your Honor,
Yes.
but
So
the 1
it's
year,
either that you are premature or you are too late.
not yet, Your Honor, because the 1 year period has not yet lapsed, Your Honor.
Well, but it has already been a completed act of foreign policy, which is that there is a communication, and to the international community, there is no defect, correct?
That's correct, Your
Yes.
Honor.
It is only amongst us in the Philippines that you claim that there is a defect.
Yes, Your Honor.
And to the international community, we are already withdrawn,
That's correct, Your
correct?
Honor.
And by international law, in order to go back to that treaty, according to its provisions, the Rome Statute, there needs to be a signing again and a concurrence. According to you, the 2 steps.
That's correct, Your Honor.
Yes. So you're too late.
And this is precisely, Your Honor, why we are asking this honorable court to rule for the certiorari and mandamus, Your Honor, so that before the 1 year period has lapsed with the ICC, Your Honor,
Who
then
represents
it
us
can
in
be
foreign policy?
withdrawn, Your Honor. The President,
The
Your
President.
Honor. Yes, Your
So
Honor.
when the court issues a writ of mandamus, do we give it to the International Criminal Court?
No, Your Honor. It
It
is
will
given.
embarrass the head of state, correct?
That's correct,
It
Your
will
Honor.
embarrass our foreign policy, correct?
Yes, Your Honor.
Because then there will be a confusion. Who is the representative? Look at it from the point of view of other countries. Who is the representative of the Philippines? Is it its head of state, the president? Now there is the Supreme Court of the Republic of the Philippines giving to us a decision which says, do not mind what the president did. Correct?
That's correct, Your Honor.
Quintessentially a political question. Correct?
No, Your Honor. Because
Why?
again, Your Honor, if the President, when we go to the
Cañada
substantive
versus
issue, Your
Cuenco
Honor,
citing Baker versus Carr. If there is any question which causes embarrassment in terms of diplomacy or foreign policy, correct?
that's correct, Your
Yes.
Honor.
And unless you can cite another case involving foreign policy where this court has issued a writ of mandamus as your precedent. The precedent now is those are quintessentially matters of belonging to politics, to the state, to the political organ, correct?
Correct, Your Honor. But with all due respect, Your Honor, going to the substantive matter, Your Honor,
If the president does not comply with a writ of mandamus, what happens?
we have a stalemate, Your Honor.
Yes, so what happens in terms of the International Criminal Court?
If it is not withdrawn by the
You will
President,
go
Your
there
Honor,
as the Philippine coalition and ask the entire international community to make a ruling on our constitutional issues, correct?
no, Your Honor.
No. So what happens?
We will have a stalemate, Your Honor. It will still go, with regard to the Philippines, Your Honor, it will have a stalemate, but with regard
Has
to the
this court
international
ever issued a
processes,
writ of mandamus against the President of the Republic?
none that I am aware of, Your Honor.
Why is that?
Because the President is with discretionary powers with regard to the exercise of his presidential prerogative,
And you are
Your Honor.
citing the case of Pimentel versus Executive Secretary, correct?
Yes, Your Honor.
Which was cited not by you, but
by the respondents,
The
Your
respondents, correct?
Yes, Your
Where
Honor.
this court clearly said that a writ of mandamus may not lie because it's discretionary, correct?
Yes, Your Honor, but again, the facts and issues of that case is
How long
different
will the
from here.
president serve?
6 years, Your Honor.
6 years. When is the end of term of the current president?
2021, Your Honor. If I'm
No, huwag mong paagain naman.
22, Your Honor.
2022.
2022,
Galing sa'yo si
Your Honor.
Solicitor General. Okay. 2022, correct?
That's
That
correct,
is
Your Honor.
3-4 years from now, correct?
That's correct, Your Honor.
Is it possible that the next president takes on a different policy, signs the statute, the treaty, and gives it again to the Senate?
That could be possible, Your Honor.
Yes. So isn't the solution to this case political rather than legal?
On one hand, arguably, you could say it's that can we
If
can also
it is
have a political.
possible that
It is
can be
possible, Your
political,
Honor. It
should
is
this
possible.
court rule?
Yes, Your Honor. Because again, with regard to Section 21, Article 7 of the Constitution, Your Honor, we are basing that the withdrawal should also have the concurrence of the Senate, Your Honor. And even if there is
We'll go to that later. There is a claim on verbal lehis, and perhaps we can examine that later. But I'm just asking you, if there is a political solution, okay, and this court wants to avoid having to issue a writ of mandamus to a co-equal branch of government, isn't the proper action of the court, legally and constitutionally, in view of its state stature within the constitutional order, to defer?
I would say, Your Honor, that in general cases, a political solution is advisable, Your Honor. But in this particular case, since what we are talking about as well are protection for victims of the most serious international crimes, Your Honor, I would say that
Are we
have
withdrawing
to go
from
into-
Republic Act 9851?
We are not, Your Honor.
Is the letter of the President served on the International Criminal Court effectively saying that Republic Act 9851 is no longer valid?
No, Your Honor.
What about Republic Act 9745?
Not. No,
What is
no, Your
Republic
Honor.
Act 9745?
It is the Anti-Torture Act of 2007, Your Honor.
What about Republic Act 7438?
No, Your Honor.
What is Republic Act 7438?
It is the Republic Act governing custodial investigation and
Yes.
interrogation, Your Honor.
And what about Republic Act 10353?
No, Your Honor.
What is
It
that Republic Act?
Anti-Enforced Disappearance Act, Your
Yes,
Honor.
you see, I know that you know because you're from the Ateneo Human Rights Center. I suppose you've memorized these laws, correct?
Almost, Your Honor.
Almost, yes. Can you now recite? No, I'm just kidding. Okay. The Constitution, in Article 2, Section 11, what does it say?
To paraphrase, Your Honor, international agreements form part of the
No,
law
no.
of the land.
Article 2, Section 11. This is the favorite of the Solicitor General. The state values the dignity of every human person and guarantees full respect for human rights. Correct?
Yes, Your Honor.
Yes. So it is in the Constitution that there is protection at that highest level of the dignity of every human person and the guarantee for full respect of human rights. Is that not correct?
That's correct, Your Honor.
Yes. And you have all of these laws. By the way, do you remember Article 124 of the Revised Penal Code?
Is it on the arbitrary detention, Your
Yes.
Honor?
So there are periods, correct?
Yes, Your Honor.
And there are penalties, correct?
That's correct,
Along
Your
with the
Honor.
other Republic Acts that I mentioned, correct?
Yes, Your Honor.
Most important of all, Republic Act 9871, correct?
Yes, Your Honor.
Yes, okay. Now, are our courts functioning?
They are, Your Honor.
In fact, the Supreme Court, we recently ruled under the able ponentia of Justice Reyes, the first Reyes, Andy Reyes, Genuino versus De Lima, protecting the right to travel. Is that not correct?
That's correct, Your Honor.
And in Spark versus Quezon City, qualifying the power of the local governments to issue curfew ordinances under the able ponentia of Justice Bernabe, correct?
That's correct, Your
Again,
Honor.
protecting human rights. Also under Justice Bernabe, Garcia versus Drilon, correct?
Yes, Your Honor.
Remember that case. The right for women to continue with the remedies under VAUSI, correct?
Yes, Your Honor.
Yes, and Estipona versus Regional Trial Court, which protected the fundamental right to plea bargain
Yes,
under
Your
the able ponentia of Justice Peralta, correct?
Yes, Your
Yes,
Honor.
and then RPN 9 versus Comelec, also by Justice Peralta. Is that not correct?
Yes, Your Honor.
Yes, and then Diocese of Bacolod, affirming freedom of speech under certain special circumstances versus Comelec. Is that not correct?
That's correct, Your
Yes.
Honor.
So this court has, by the way, has there been writs of amparo filed against summary killings.
Yes, Your Honor.
Yes. Has there been a writ of amparo, to your knowledge, that has been denied by the Supreme Court of late?
Not that I am aware of, Your
None.
Honor.
Correct? Most of it we have remanded to the lower courts to actually hear the evidence, except of course the obvious ones where the writ of amparo does not apply. But for summary killings, we have issued the writs of amparo. Is that not correct?
That's correct, Your
In
Honor.
fact, this court is so functioning that it is actually seized of a case involving the policy on tokhang and double barrel. Is that not correct?
Yes, Your Honor.
Yes. So, in accordance with all of this, there is protection on human rights within the domestic sphere, correct?
I would argue, Your Honor, that there would be protection only if cases have actually been filed by those who are victims of human
Okay.
rights violations.
And
Your
why
Honor.
have the others not been filed? Is it the fault of the government?
Yes, Your Honor. It is also the fault of the government in the sense, Your Honor, that
If
there
there
has
is a
been threats.
violation of a law and there are victims, isn't it incumbent on human rights practitioners like you and NGOs to collect the data, look for the specific cases, and file them with a trial court? Is that not correct?
That's correct, Your Honor.
Yes.
But the reality, Your Honor, is that, for example, Your Honor, with regard
Well,
to the
excuse
drugs,
me, reality where? In Bacolod?
in the reality
In Mindanao?
in the
Visayas?
Philippines at the moment, Your Honor.
You are ready to make a generalization.
Based on a personal observation, Your Honor.
You are ready to make a generalization based on your personal observation. Have you been to Batanes lately?
No, Your
Lawag,
Honor.
Baguio, Tabuk,
Yes.
Cotabato.
No, Your Honor.
Okay. In other words, that there are no actual cases that have been filed, is that the breach of human rights that you are claiming?
If
Because
the
I remember
victims are
during
not...
the time of martial law, I was with the Free Legal Assistance Group. And left and right, we were filing cases with trial courts, notwithstanding the difficulties during that time, I mean the martial law during the Marcos era, left and right. And I remember as a young practitioner carrying the briefcases of many of the lawyers, we looked at evidence of each and every case. And from each and every case built the claim that there were fundamental, widespread, systematic violations of human rights. Is that happening now?
Yes, Your Honor, but from our experience, Your Honor, many of the victims that have
Or
been
have you chosen to
investigated...
simply go to the Supreme
Choose-
Court and make generalizations?
No, Your Honor.
Have you handled the case yourself?
Yes,
on
Your
summary
Honor.
killings?
I have handled cases that have been brought before me, Your Honor, but have not been able to file it because of the fear of the witnesses and the victims and families of the victims, Your
Yes,
Honor.
it's standard that in any case where it is against government, there has to be a support group. During our time, it was task force detainees, many others, to actually support the filing of the case. It will take some time to gestate it, but we have to evolve first all of those violations in order to make a claim that there is lesser protection to our on human rights. For example, there are judges in various stations who will be insulted when we tell them that they are not functioning, that they will not receive any case on human rights because we have withdrawn from the Rome Statute. Isn't that correct?
Yes, Your Honor, but this is the complementarity principle of the Rome Statute, Your Honor.
We will go to that later.
Yes,
Okay.
Your Honor.
In other words, do you agree with me that there are normatively sufficient protection for human rights?
I would say that there are institutions that should be giving protection, Your Honor, but
In fact,
I
there
would...
is still a Commission on Human Rights, correct?
Commission on Human Rights is a watchdog,
Yes.
Your Honor.
Okay.
But
But it's still there, correct?
it's still there, Your
The
Honor.
legislature is still there, correct?
Yes, Your Honor.
It can pass a law, correct?
That's correct, Your
There
Honor.
are advocates in the legislature, correct?
Yes, Your Honor.
Among which are the petitioners in the other petition, correct?
Yes, Your Honor.
Who can actually tighten the laws, if possible, correct?
Correct, Your Honor.
As a matter of fact, it was possible to pass Republic Act 9851 before the ratification of the International Criminal Court. Is that not correct?
Yes, Your Honor.
And in fact, it adopted most of the definitions of crimes in that law.
Yes, Your
correct?
Honor.
Yes. So, in other words, your claim that there is lesser protection to human rights is on the basis of what?
On the basis, Your Honor, that at present, we have personal knowledge of complaints that have not been filed in court but have been brought to the attention of...
Numbers. Let's be scientific counsel. You have personal knowledge. The one sitting across your table will also have personal knowledge. But should this court proceed upon anecdotal evidence?
No, Your Honor.
But even if I want to believe you, should I proceed as a member of this court on anecdotal evidence?
No, Your Honor.
Or should I base my judgment simply on the basis of evidence, facts, correct?
That's correct, Your Honor.
Yes. And therefore, your claim that there is a weakening of protection on human rights is a factual claim.
It is, Your
Yes.
Honor.
And this court is not a trier of facts.
That's correct, Your Honor.
Yes. And we can only go by your word, correct?
Yes, Your
Or
Honor.
should we?
Not as a trier of
So
facts, Your
maybe
Honor.
this should have been filed with the trial court.
Again, Your Honor, with regard to the substantive aspect, Your Honor, we will be arguing that it's twofold, Your Honor. The two-third requirement of concurrence of the withdrawal was not satisfied.
What
And
is
other
the
one-
violation on human rights that you fear the most that will be not protected by the withdrawal from the ICC?
Impunity, Your Honor.
No,
the
what is
lack
the
of a right to an
impunity is
effective...
a general
Yes, Your Honor.
state. What is the violation of human rights?
But the lack to a right to an effective remedy, Your Honor.
That's so general. What is the actual case?
The actual case at the moment, Your Honor, is war crimes. I'm sorry, crimes against humanity, Your Honor. I
What
stand
specifically?
corrected.
Crimes against humanity, there are four parts there.
That there is a systematic attack against a civilian population through many of the killings that
Summary
have been
killings,
happening, Your
correct?
Honor. Yes, Your Honor.
But Article 127 says that the withdrawal only has the effect as of the time of the withdrawal, correct?
That's correct, Your Honor.
And in terms of ratione temporis and subject matter jurisdiction and jurisdiction over the person, whatever situation happened prior to the communication of the withdrawal is not affected by the withdrawal, correct?
That's correct, Your Honor.
So, in terms of the actual crime that you are so scared that will not be covered, it is actually covered by the International Criminal Court, correct?
Up to the moment of the submission of the letter of withdrawal,
Yes, but
Your
if
Honor.
it were committed by perpetrators, that will be the same. After the submission of the letter, it will be sufficient, correct?
After, Your Honor, it would not be covered anymore.
In other words, will the withdrawal affect the preliminary examination by the Office of the Prosecutor?
Up to the point that, no, Your Honor, up to the point
It will
that
not affect it, correct?
it is within the 1-year period before
Yes.
the withdrawal.
So we want to create a situation where the Supreme Court issues a writ of mandamus for the President because the actual right has not yet really been violated. There is preliminary examination ongoing. It cannot be stopped by the withdrawal, correct?
Yes, Your Honor, it
So
cannot be stopped.
again, what is the actual case?
Well, we are banking ourselves on the transcendental importance, Your Honor, of, again,
Wait,
one...
excuse me.
trans-
Just because there is something of transcendental interest, the court must step in. Isn't it the doctrine that transcendental interest is only an exception on standing, but not on the requirement of actual controversy?
That's correct, Your Honor.
Yes. So again, we go back. What is the actual controversy?
The actual controversy here, Your Honor, is that the right to an effective remedy is deprived
Again,
from
which
victims.
effective remedy? I have cited the laws. I have cited that our courts are functional. I have cited that this Supreme Court has in fact opened up to this petition. And many petitions, in fact, the last petition was even on same-sex marriage, correct? And the petition before that we heard was on, I think, tokhang and double barrel, if I'm not mistaken. So it's functioning. What remedies have been curtailed?
At the moment, Your Honor, we are not talking about just the courts, Your Honor. At the moment, victims of human rights violations, particularly those covered under...
You mean the International
The-
Criminal Court will come here and help
No,
the
Your-
victims?
No, Your Honor.
So-
But again, it goes into that principle of complementarity, Your Honor. That if there is no effective remedy being given because the victims
I'm
are
sorry,
unable
but
to file
complementarity
cases.
in Article 17 of the Rome Statute says, unwillingness and inability, correct?
That's correct, Your Honor.
Inability means a substantial degradation of the judicial authorities within the country involved, such that no hearing can be heard impartially, independently, correct?
That's correct,
Are
Your
you now
Honor.
claiming that our courts are unable to receive cases?
It is able to receive cases, Your Honor, but again, in terms of
Are you now
the investigation
claiming
of
that
these
the
cases, Your Honor,
judiciary, the entire judiciary, is unwilling to address cases that will be filed or have been filed involving the crime that you're mentioning, widespread or systematic willful killing?
that is not our position, Your Honor.
Yes, so again, what is the actual controversy?
Again, Your Honor, the actual controversy for the petitioners in this case is that the fact that since the victims are unable to file cases, not because of the unwillingness or inability of the courts, but for example, there is no
But you just
proper
said that
investigation,
the
Your
Rome
Honor.
statute requires complementarity.
Yes,
Maybe
Your
we
Honor.
should clarify that. It doesn't mean that the cases will go side by side,
It
correct?
doesn't mean, Your Honor.
It means that it's like exhaustion of remedies, correct?
Yes, Your Honor.
Yes.
And if there is inability to investigate killings that are happening with regard to the drug war, for
So
example,
there
Your
is
Honor,
inability now.
then it is our position that there is inability, Your Honor, with regard to the investigation and
You are
prosecution of
making a
these
factual
cases.
claim, correct?
Yes, Your Honor.
Yes, and you want us to agree with your factual claim on the basis of what?
Your Honor, our position is
I
not...
mean, we are designed as a court to stay in a high bench,
Yes, Your Honor.
okay? To move ourselves 20 steps backwards and allow the parties to present evidence so that personal anecdotal references will not be what we will base our judgment on, but on the evidence and the proof that is created, correct?
Yes, Your Honor.
Yes. So, again, isn't this a factual question?
The actual case here, Your Honor, is the lack of concurrence with regard to the withdrawal of...
No, I thought you said it was the degradation of the remedies to human rights victims.
That is the effect, Your Honor.
The effect. Okay, so the actual case
Is the lack of the two-thirds concurrence in the withdrawal,
you change your
Your Honor.
theory.
No, Your Honor. It is all connected, Your Honor.
Yes, so it is a public right, correct?
Yes, Your Honor.
Yes, and you are not a senator.
I am not a senator, Your
So
Honor.
what is your standing to raise that?
Your Honor, as a citizen of the Republic of the Philippines, Your Honor, again, the withdrawal, the unilateral withdrawal without the concurrence of the Senate, Your Honor, effectively deprives me of that effective remedy, Your Honor.
Because, is it an effective remedy? I thought that on the first layer is that there must be a showing of unwillingness and inability, correct?
That's correct, Your Honor.
Yes. Have you heard of the ruling of the Office of the Prosecutor of the International Criminal Court on British soldiers in Iraq?
Is this the one for the preliminary examination, Your Honor?
The
Yes, Your
ruling.
Honor.
What was the ruling?
My recollection, Your Honor, is that it's still under preliminary examination, Your Honor.
No, it was finished. Correct? The prosecutor said that while there were certain cases that there may have been willful killing or torture, etc., under Article 17, the gravity was not as much as would be required by the International Criminal Court. Is that not correct?
I submit, Your Honor.
Because Article 17 requires two things, correct?
Yes, Your
One
Honor.
is complementarity. In fact, it is in paragraph 10 of the preamble also in Article 1 of the Rome Statute, correct?
Yes,
it
Your Honor.
means complementarity. And the second is the offense must be grave enough, correct?
Yes, Your Honor.
And grave has not yet been fully defined
Yes, Your
under
Honor.
the mechanisms under the International Criminal Court, correct?
Yes, Your Honor.
But generally, it can refer to scale, quality, the quantity of the violations, etc. Is that not correct?
Yes, Your Honor.
Under Republic Act 9851, is there a requirement for gravity before a prosecutor from the DOJ can prosecute under the crimes in 9851?
There is no mention, Your Honor.
None. So, in other words, it is better to go through 9851 because any kind of offense involving the 4 core crimes under the Rome Statute can be prosecuted under the domestic sphere, correct?
Yes, Your Honor.
And there is no complementarity involved. There is no Article 17 involved. There is no gravity required, correct?
Yes, Your Honor.
Yes. So, you mean that we have diminished the remedies of the victims, or we have just increased it?
Your Honor, with Republic Act 9851, Your Honor, definitely it has given more remedies to the victims, Your Honor. But again, if the state itself would be unwilling or unable
Have we
to
adopted
prosecute.
the entirety of the crimes in the Rome Statute in 9851?
As far as I know, for the 3 crimes, Your Honor, except for the
Aggression.
crime of aggression, Your Honor.
Because we cannot penalize anybody on aggression,
Yes, Your
because
Honor.
it should involve a foreign power, correct?
That's correct, Your Honor.
And, well, of course, your favorite, Section 6, crimes against humanity includes widespread or systematic attack directed against any civilian population with knowledge of such attack, willful killings, letter A, correct?
That's correct,
It's
Your
also
Honor.
in the Rome Statute. It's also in 9851, is that not correct?
Yes, Your Honor.
An exact copy of the Rome Statute, correct?
Yes, Your Honor.
Even the phrase with knowledge of such attack, correct?
Yes, Your Honor.
Of course, the preparatory discussions on with knowledge of such attack meant something on the international sphere, correct?
Yes, Your Honor.
But we still copied it anyway.
Yes,
right?
Your Honor.
And in fact, our law has expanded some of the crimes, correct?
Yes, Your Honor.
Like, for example, not only conscripting or enlisting child soldiers, but we included something taken out during the discussions for the Rome Statute, recruitment, correct?
Yes, Your Honor.
So, 9851 is even more expansive than the Rome Statute. Is that not correct?
we submit, Your Honor.
Yes. Therefore, why are we here? What is the problem of the petitioners?
Again, Your Honor, if the domestic solution is unavailable to the human rights victims, Your
But
Honor,
again,
then
is it now unavailable?
it is still available at the moment, Your Honor, for the Rome Statute, simply because it will take
No,
effect.
the remedies for the victims, are they unavailable now?
They are available, Your
They are
Honor.
available.
Again,
The courts are willing,
the courts are willing, Your Honor.
the courts are able,
Yes, Your Honor.
yes. The only problem is making the case, correct?
That's correct, Your Honor.
Yes, and making the case, of course, is not the coverage of the International Criminal Court.
When the International Criminal Court examines or investigates, Your Honor, it does not look merely at how the judicial department functions, Your Honor. It also
Oh,
looks
of course it does. Under Article 17,
Yes.
complementarity.
Yes, Your Honor.
Because it cannot, can trigger jurisdiction, yes,
Yes, Your Honor.
but the court will not have jurisdiction because the case will not be admissible, correct?
Yes, Your Honor. But
Okay,
it also
so
looks...
jurisdiction involves under the Rome Statute, subject matter jurisdiction, personal jurisdiction, time jurisdiction, and crime, correct?
That's correct,
And
Your Honor.
after jurisdiction, you have to establish its admissibility, correct?
Yes, Your
And
Honor.
admissibility is a matter of, number one, have they passed the test of complementarity, correct?
Yes, Your Honor.
Number two, is it serious enough, correct?
Yes,
And
Your Honor.
complementarity includes two things, unwillingness and inability, correct?
Yes, Your Honor.
So inability means no more functioning courts or substantially degraded functioning courts, correct?
Not necessarily, Your Honor.
What do you mean not necessarily?
Again, Your Honor, if the victims are unable to file cases before the courts,
Oh, is that the definition of inability in
under
Rome
Article
Statute?
17,
Show me.
no, Your Honor, it is
Show me.
the inability of
The state.
state, Your Honor.
Yes. It's not an inability of the victims, correct?
Yes, Your Honor.
Because truth is, the International Criminal Court, will they send peacekeepers?
No, Your Honor.
Will they send an army of investigators?
No, Your Honor.
The prosecutor, will it rely on information that is given to her?
Yes, Your Honor.
Yes. And that information given to her will likewise also be available if courts are available in the country, correct?
That's correct, Your
Yes.
Honor.
So that's inability and unwillingness, correct?
Yes, Your Honor.
So again, can you clarify to me, to this court, what exactly has been degraded? the crimes that have been defined under 9851, and I gave you an example, that we've expanded the concept of a child warrior, not only conscripting and enlisting, we included recruitment, correct? Tatlo na yon. And also, everything was copied in toto from the Rome Statute in terms of the definition of crimes, correct?
Yes, Your Honor.
Yes. So what has been degraded?
The inability, Your Honor, that Article 17 speaks of, Your Honor, is not merely inability of the judicial,
So
the
theoretically,
judiciary
you are
to function,
saying
Your Honor.
the treaties must be approved by a 2/3 concurrence of the Senate, correct?
That is what our
Yes.
Constitution provides, Your
But
Honor.
we have a different situation here. We have the core content of a treaty established as law,
That's correct, Your
correct?
Honor.
So it is not simply incorporation under Article 2, Section 2, or Article 7, Section 21. It is also incorporation by the passage of a law from Congress, correct?
Yes, Your Honor.
Yes. Now, are we withdrawing from that Republic Act?
No, we are not,
Yes.
Your Honor.
So, in terms of protection, it is still there, correct?
Yes, Your Honor.
So, your question regarding the 2/3 concurrence is simply theoretical and for this court going to be advisory, correct?
No, Your Honor.
Maybe we should wait for the proper case where the treaty has not been enacted by statute in order to be able to rule on the constitutional issue, because according to our jurisprudence, if we can avoid the constitutional question, we should, correct?
Yes, Your Honor. But
Because we do not want to cover all instances where there may be a different situation that we have not predicted under this particular case, correct?
yes, Your Honor. But Republic Act 9851, Your Honor, does not make us a state party to the Rome Statute of the
Yes, why
of
do
the
you want to be a
ICC.
party to the Rome Statute? What does it add in terms of protection to those with locus standi in this court?
Again, Your Honor, if the state is unable and unwilling to prosecute cases.
Yes, but that is not yet our situation, correct?
Yes, Your Honor, but we do know for a fact
Are
that
you
there is a
predicting that this court will be
preliminaries.
unable to manage all the other courts?
that is not our position, Your
Okay,
Honor.
if you are speculating that in the future we may not be able to do that, okay, then therefore your remedy is political in nature. Go back to the president, vote for another president. Of course, the president cannot run for the elections according to the Constitution, and then go to the Senate again, correct? But it is not for this court to address a future speculative situation, correct?
That is the political
You are going to empower
solution, Your
us so
Honor.
much, we will become so, powerful without being accountable to an electorate, correct?
Yes, Your Honor.
Yes. Why is the president the head of state, not the court?
Because he's the head of the executive branch
Yes,
of
why?
government. Because he directs the affairs of the state,
No,
Your Honor.
no, that's the effect. Why did the Constitution grant the president the power to become the head of state?
Because he represents the Republic, Your Honor, in
Yes, because he was
international
elected at large,
relations,
correct?
Your Honor.
Why
Yes,
not
Your
make Congress do it?
Honor.
Congress is also elected, correct?
That's correct, Your
What
Honor.
is the theory under the constitutional doctrine that it is the president who is the head of state? What is the policy behind it?
Your Honor, the president executes the legislative intent.
Not as
of-
head of state. The president is chief executive, commander-in-chief, head of state. Those are the three personalities in the president, correct?
Yes, Your
So,
Honor.
executive is to execute, correct?
Yes, Your Honor.
Now, commander-in-chief is to command. We've
Yes,
tackled that in the martial law cases, correct? Now, this one is head of state.
Yes,
Different,
sir.
right?
Yes, Your Honor.
Okay, so as head of state, why is it the president?
Your Honor, he's the one elected, Your Honor, a person
Yes,
with regard
why not Congress? Congress is
because
also elected.
they are a collegial body, Your
Yes.
Honor.
And you need, in terms of foreign policy, decisions made at present, contingent, necessary, sometimes as a matter of emergency. The crafting of foreign policy, therefore, is granted to that organ that can operate at the present, correct?
Yes, Your Honor.
Judiciary operates from facts that have already been. Congress for the future, correct?
Yes, Your Honor.
Yes, so the president, therefore, is the head of state and therefore architect of foreign policy. Is that not correct?
That's correct, Your Honor.
Yes, and therefore, since the president is the head of foreign policy, is the withdrawal not in effect an offshoot of his foreign policy?
Your Honor, if it is done in a whimsical, arbitrary, and capricious manner, Your Honor, which makes it based on the expanded judicial power of this honorable court, then it can be unconstitutional, Your Honor.
It's a political decision, correct?
Foreign policy itself is a political decision,
Yes.
Your Honor.
And political decisions are based on how the president feels, the taste of his electorate are. In other words, he feels that this is the way to protect it, correct? And he has his reasons for doing so, right?
Your Honor, traditionally it is, Your Honor, but
From the point of view of
because
the respondents, according to them, essentially it is because human rights has been so weaponized, if I may borrow from the respondents' pleadings.
Your Honor, again, traditionally, the President has discretion with regard to foreign policy, but because the Constitution has put limits as to this power of the President, Your Honor.
You want this court to issue a writ of mandamus simply because you do not like the decision of the President.
Our position is that it goes against the mandate of the Constitution, Your Honor, and we must follow the
President.
dictates of the Constitution, Your Honor.
Yes, the President, when he decided to withdraw from that treaty, violated the Constitution.
Because it did not get the concurrence of the Senate, Your Honor.
Okay. What is the basis of your claim, textually?
It is not in Section 21.
Article 7, Section 21. Let us read it very carefully. What does it say?
Section 21, Article 7,
Yes.
Your Honor. No treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate.
Okay. Where does it say that that creates law? Can you look at Article 2, Section 2?
The Philippines renounces war.
Adopts the generally accepted principles of international law, and look at this phrase, as part of the law of the land. Correct?
Yes, Your Honor.
Okay, let's go back to Article 7, Section 21. Where does it say there? The treaty becomes part of the law of the land.
Your Honor, it's in Section 2, Article 2, as you
Yes,
mentioned.
generally accepted principles of international law. That's
Yes.
incorporation of customary international law, general principles. This one is for treaty, correct?
That's correct, Your
Yes, and it says, no treaty or international agreement shall be valid and effective, that did not say effect of law, unless concurred in by 2/3 of by the Senate, correct?
Honor. Yes, Your Honor.
Yes.
But
So the formulation itself, does it not support the theory of the respondents? In terms of treaties, it is ratified by the President,
Yes, Your Honor.
correct? And the only check is that the Senate concurs. And by the Senate concurring, it is not a legislative act. It is an act of foreign policy. So the Senate's concurrence is a check on foreign policy, correct?
That's correct, Your Honor.
Yes. And therefore, since it's a check on a power of another organ, we should not expand the provision to include something which is not there.
On the contrary, Your Honor, if we talk about the effect of a treaty or an international agreement, Your Honor,
Yes.
the reason why it was based on the Constitutional Commission deliberations, Your Honor, it really served as a check in order to ensure that treaties and international agreements would be concurred in by the Senate because it would have a domestic effect, Your Honor. And inversely, Your Honor, any withdrawal would also have an effect in this particular case on a right for an effective remedy that has already been vested to many Filipinos, Your Honor. It is inversely and corollarily applicable that the concurrence of Senate must also be given in this withdrawal, Your Honor.
Where
it is
does it
not
say
written-
inversely?
Well, it is not written, Your Honor, but
Okay.
we are looking at the intent of the Constitutional Commission, Your Honor.
The intent of the
Constitutional Commissioners, Your Honor.
50 who were appointed.
Yes, Your Honor, for the
Or in fact,
1987
48
Constitution.
that actually voted.
Yes, Your Honor.
Yes, as against 100 million Filipinos today, reading the text. Had they wanted the inverse, why did they not put it there?
Your Honor, again, if we look at the intent of the constitutional framers, Your Honor, they wanted a check on this power
No, my question
of
is,
foreign.
had they wanted it to actually bind the president in terms of withdrawal, why did they not put it in Section 21 or somewhere in the Constitution?
I will not be able to speculate on that, Your Honor.
Perhaps because they did not intend it that way.
That would be speculative, Your Honor.
Why would it be speculative? Isn't yours more speculative?
No, Your Honor, because again, the
Because
intent
as I
is
read
to
the
have...
Constitution, and if I were
check.
only, excuse me,
Yes, Your Honor.
if I were only reading the Constitution, which was, by the way, were the deliberations of the CONCOM presented to the people during the plebiscite?
No, Your Honor.
Really? So why are we using it as a aid to interpretation?
It was not presented, but
What was
it was
presented to the people? Was it this provision?
the text of the Constitution,
Yes,
Your
and
Honor.
it was the text of the provision that was ratified, correct?
Yes, Your Honor.
And in the text of the Constitution, it does not say, when the President exercising his powers of foreign policy withdraws from a treaty, it needs also Senate concurrence.
We submit, Your Honor, that it's
It
not in the
doesn't say
text,
that.
Your Honor.
So
Yes, Your
therefore,
Honor.
it is possible and reasonable for this court to rule that there is no such requirement.
It's possible for the court to
It
rule
is
on that,
possible
Your
for
Honor.
this court to rule because the President's term is only 6 years.
Yes,
And
Your
that
Honor.
after 6 years, he will have to give it to the electorate if he really wants to join again that treaty, then therefore again sign the treaty and the Senate to concur, correct?
Yes, Your Honor.
Unless the Senate and the House get together and pass a law, correct?
Yes, Your Honor.
In which case they did in 9851, correct?
Yes, Your Honor.
In order to assure the protection domestically, correct?
Yes, Your Honor.
Yes, and therefore the withdrawal of the treaty does not have an effect on the protections granted by our legal norms on human rights to our people, correct?
Again, Your Honor, the withdrawal from the Rome Statute on the ICC, Your Honor, has effectively or will effectively withdraw further
You trust
remedies.
foreigners to rule on crimes more than this Supreme Court and our lower courts?
Your Honor, if there is an inability to bring cases before the
Yes,
courts,
is
Your
there
Honor,
an inability? We go around in circles. What is the situation now? Is there an inability of our trial courts? You tell us because we are here in the Supreme Court.
The courts are
Magsumbong ka.
open.
Is there inability of our trial courts to attend to human rights cases?
there is no inability, Your
No
Honor.
inability. Is there an unwillingness of our courts to attend to human rights cases?
Not with the courts, Your Honor.
Not with the courts. So, again, what is the right that was violated? What is the prerogative that was violated? As a matter of fact, there is reverse complementarity in 9851. Is that not correct?
Yes, Your Honor.
Where is it found? Chapter 8, Section 17. Correct? In the interest of justice, the relevant Philippine authorities may dispense with investigation or prosecution and give it to another court or an international tribunal. Correct?
That's correct, Your Honor.
So, isn't this unconstitutional by itself?
I would,
Crespo versus Mogul, whenever a trial court already has jurisdiction, it maintains that jurisdiction. Here, it appears to say, walang kwenta pag Filipino court. An American serviceman is caught committing a crime. If there is a court in the United States already seized of that, our Philippine courts must give way according to this. Correct?
that's correct, Your Honor.
Reverse complementarity. Correct?
Yes, Your Honor.
So, in other words, there is here a statement that our judiciary is second class to the International Tribunal and to other courts.
I wouldn't want to speculate on that, Your Honor.
Because it is not, correct?
Yes, Your
Because
Honor.
your judiciary can be able, correct?
Yes, Your Honor.
Can be enabled, correct?
That's correct,
Can
Your Honor.
improve and become more efficient, correct?
That's correct,
And the
Your Honor.
better that it will become more efficient so that we will have to rely on ourselves, correct?
Yes, Your Honor.
That's self-determination, correct?
That's correct,
That
Your
is
Honor.
sovereignty, correct?
Yes, Your Honor.
Yes, and therefore, 9851 is enough.
As a domestic remedy,
So
Your
our
Honor,
withdrawal from the International Criminal Court therefore need not be ruled upon by this court.
again, Your Honor, if we look at the action of the Chief Executive based on the requirements of the Constitution, Your Honor, and furthermore, based on whether
Yes.
it was exercised.
Why should we rule on whether or not there needs to be a two-thirds concurrence for the withdrawal when we are satisfied that in terms of human rights protection, there is enough?
Your Honor, protection will only be, we will only be satisfied with
Well,
protection,
is it
Your Honor,
because you
if
want to embarrass the
cases-
President?
No, Your Honor.
Is it because you want to embarrass this administration?
No, Your Honor, because
okay.
the ratification of the Rome Statute.
And by the way, the examination started by the prosecutor on the current situation, as it alleges, will it be stopped by the withdrawal?
No, Your Honor,
It will not.
it will not, Your Honor, based on facts that
So,
have been happening up
you-
to 1
You
year.
still want us to rule on something that need not be ruled upon?
Again, Your Honor, if it is not based on the mandate of the Constitution, Your Honor, yes, Your Honor, we would like to, for this honorable court to rule on it, Your Honor.
Okay. There is customary international law and there is treaty law, correct?
Yes, Your Honor.
Yes. Can we withdraw from customary international law?
No, Your Honor.
Can we withdraw from treaty law?
Yes, Your Honor.
Yes. By getting out of the International Criminal Court, have we withdrawn from any international customary norm?
No, Your Honor.
None. Is the International Criminal Court, that procedure there, is that customary norm?
The procedure itself is not, Your Honor.
Is complementarity customary norm?
Complementarity, yes, Your Honor.
Customary international law?
Complementarity, Your Honor.
Yes. Is there
In
opinion
terms of-
juris and state practice sufficient enough to create it as customary international law?
Well, I believe, Your Honor, if it goes into access to different bodies,
Are you
Your
familiar
Honor.
with the International Court, Criminal Tribunal of Yugoslavia?
Yes, Your Honor.
Yes. Was it created through the International Criminal Court?
No, Your Honor.
How was it created?
By a UN resolution, Your Honor.
Which UN body?
If I'm not mistaken, the Security Council.
Security
Your Honor.
Council. Are you familiar with the International Criminal Tribunal of Rwanda?
Yes, Your Honor.
How was it created?
Same, Your Honor.
What about special courts on Sierra Leone?
Yes, Your Honor.
How was it created?
Again, same, Your Honor. These are the
Okay.
ad hoc courts,
Is
Your
the
Honor.
are the special courts on Sierra Leone, not Leonen, okay? Leone, an international criminal tribunal.
Yes, Your Honor,
Only
but
in terms
only
of its
limited,
creation?
with limited jurisdiction.
Yes, but
Your Honor.
also it is only within Sierra Leone, correct?
That's correct,
Yes,
Your Honor.
unlike the controversies in Rwanda and Yugoslavia, where there were transboundary issues, in Sierra Leone, it was only within Sierra Leone, correct?
Yes, Your Honor.
Yes, and therefore, there are many other ways to institute criminal tribunals other than the International Criminal Court. True or false?
True, Your Honor.
Yes. So therefore, we lose nothing. Are we a member of the United Nations?
We are, Your Honor.
Yes. By the way, who are not members of the International Criminal Court? Let me ask you. Is the United States a member?
It is not, Your Honor.
No, it signed in 2000, but did not
It
ratify.
unsigned. It also unsigned. Your Honor.
Unsigned.
Yes,
What
Your Honor.
about Russia?
I don't think so, Your Honor.
What about China?
No, Your Honor.
Yes. So therefore, there are significant countries with nationals who are sent to peacekeeping missions, who are sent abroad through their intelligence operatives that are not part of the International Criminal Court.
Yes, Your Honor.
Yes. Are they violating customary law because they are not part of the International Criminal Court?
No, Your Honor.
Yes.
But in fact, these peacekeeping forces, Your Honor, if I may, Your Honor, if they find themselves here in the Philippines, Your Honor, and violate the Rome Statute, they can be held liable under the Rome Statute, Your Honor, simply because they are found in a state party, Your Honor,
Before we withdrew.
before we have withdrawn, Your Honor.
Yes. Can a non-party, a state which is a non-party, avail of the International Criminal Court?
They can, Your Honor.
Yes. So, after the administration finishes, this administration, is it possible for the next administration to actually trigger jurisdiction via communication to the prosecutor?
That's possible, Your
That's
Honor.
possible. So, that remedy is also still there.
But that is a political remedy, Your Honor.
Yes, like everything else, correct?
Yes, Your Honor.
Yes. As a matter of fact, certain other things happen within the International Criminal Court unimagined by those that actually ratified it. For example, there were self-references. There were countries that actually went and said, come investigate us, correct?
That's correct, Your Honor.
For example, Uganda, correct?
Yes, Your
The
Honor.
Lord Resistance Army, correct? The Central African Republic, correct?
Yes, Your
Congo, for that matter, right? So it is possible for other countries to find a way to to involve the International Criminal Court. Is that not correct?
That's correct, Your
So I
Honor.
ask you again, given that we have protections already under our laws, given that this court stands able and willing to receive cases on human rights, okay, given that there are many other ways to trigger international jurisdiction other than the International Criminal Court, given that you just need to wait for maybe 4 years and convince another president to act politically and involve the Senate, do we have to rule on the constitutional issue as to the withdrawal?
Again, Your Honor, we will stand by our petition, Your Honor, and our stand that there is a need to rule, Your Honor. One, on the basis that it is the mandate of our Constitution.
Yes.
Second, that it cannot be exercised, the withdrawal cannot be exercised in an arbitrary, whimsical, and capricious fashion. And third, it cannot effectively
I'm sorry.
deprive.
Why was the withdrawal arbitrary?
Your Honor, based on the statement of withdrawal itself, Your Honor,
Yes.
it is our position that it has been withdrawn arbitrarily considering the protection that the Rome Statute is supposed to give.
The president felt that human rights at an international level is weaponized. That's in the respondent's comment.
Yes, Your Honor.
Isn't that the reason that the United States withdrew from the UN Commission on Council on Human Rights?
Yes, Your Honor.
Yes. So that's also arbitrary. When a country feels that human rights is being used as a political agenda for others, that is whimsical and arbitrary.
Your Honor, if I may, Your Honor, it would be difficult to compare the UN Human Rights
Or
Council with the Rome
does it
Statute,
make sense
Your
to you
Honor.
only because you are of a political bent?
No, Your Honor.
And you want this court to accept your political leanings?
That's
And
not
therefore
the intent,
accept
Your
it.
Honor.
So-
Again, the petitioners here, Your Honor, have been battling against impunity, Your Honor, regardless of whatever administration,
What do you mean?
regardless of political
When
color,
we
Your Honor.
withdraw from the International Criminal Court, we are acknowledging impunity? I thought you
We
just
are-
accepted that the courts are still functioning.
Yes, Your Honor. But
Yes.
again, the Rome Statute gives additional
Yeah,
right
so,
to...
just so we're very clear.
Yes, Your Honor.
The Rome Statute creates a court,
That's correct, Your Honor.
creates a prosecutor.
Yes, Your Honor.
They do not come here and send all their investigators to help with the Commission on Human Rights, to help the NGOs gather the evidence, correct?
Not at all, Your Honor.
Okay. In fact, they will rely on evidence that will be produced by the NGOs that are here in the Philippines, correct?
Yes, Your Honor.
Yes.
And as mentioned by Attorney Andres earlier, Your Honor,
So-
only when the Philippines has failed.
Again, perhaps in your memoranda, you will convince me more that there is a diminishment of the protection, given that what I see is it is not yet there, if you predict that it will happen. By the way, your petition was filed late, correct?
Sorry, Your Honor.
You filed your petition more than 60 days from
That's
the
correct,
time
Your
that the
Honor.
withdrawal was submitted, correct?
Yes, Your Honor.
Yes. So should we not dismiss your petition outright?
No, Your Honor. Because
Because-
the action is a continuing violation
You are
of the
familiar with the case
Constitution.
of Araulio versus Aquino, correct?
Yes, Your Honor.
Where the Supreme Court made a distinction between certiorari for extraordinary jurisdiction and certiorari under Rule 65, correct?
Yes, Your Honor.
And that certiorari under extraordinary jurisdiction is no longer covered by Rule 65, correct?
Yes, Your Honor.
Not really that covered. And then there was the subsequent case of, by the way, who was the ponente in Aquino? Araulio versus Aquino. I need to mention him, Justice Bersamin, correct? And then it was followed by AMCO versus Dole. The ponente there was Justice Brion, correct? Okay. I have no further questions, Chief.
Thank you, Your Honor.
Attorney Bagares.
Good afternoon, Your Honor.
Good afternoon. Counsel, executive power under the Constitution is vested in the President, correct?
Sorry, Your Honor, I couldn't hear the question, Your Honor.
Under the Constitution, executive power is vested in the President.
Yes, Your Honor.
And under the oath of office of the President must faithfully and conscientiously execute the laws, correct?
Yes, Your Honor, that's the oath of office taken by the President, Your Honor.
And also under Section 17 of Article 7, the President shall ensure that the laws be faithfully executed, correct?
Not only the laws, Your Honor, but the Constitution itself, Your Honor.
Yes. The President's primary duty is to execute the law, correct?
It's one of the duties of the President, but the primary duty, Your Honor, is to observe, to make sure that the Constitution is followed, Your Honor.
Yeah, that's to execute the law. The law,
Yes, Your Honor.
Constitution is part of the law of the land.
Yes, Your Honor.
So the executive executes the law. Now, where is legislative power vested?
It's in Congress, Your Honor.
Okay. And can Congress by itself pass a law without the participation of the President?
Yes, Your Honor.
So, but ordinarily, the President has to sign and give its approval to the law. But if the President objects, he has to send his veto message, and it can be overturned.
Yes,
correct?
Your Honor.
Overridden by the Congress. So, legislative power is lodged in Congress.
Yes,
and
Your Honor.
Congress by itself can pass a law over the objection of the President, correct?
Yes, Your Honor.
Okay. Now, if two laws are in conflict and the conflict is irreconcilable, which law will prevail?
Your Honors, this court has come up with several resolutions, depending, Your Honor, on the type of laws we're talking about, Your Honor.
Yeah.
We have rules, for instance, Your Honor, the rule on lex superior derogat inferiori. We also have lex superior derogat priori, Your Honor, so, which it's usually used with the court with respect to treaties. So the later law
Now,
will
my
supersede.
question is, there is a law of Congress and passed with 1 year, and Congress passes another year in a subsequent, another law in a subsequent year, and both are irreconcilable. Which law will prevail?
Well, that would be the later law, Your Honor.
The later law
Yes, Your Honor.
prevails.
That's the concept of lex superior derogat superiori, Your Honor.
Assuming they are both general laws.
Yes,
okay?
Your Honor.
Now, what is the status of a treaty under Philippine law?
From the latest decision of the court, Your Honor, in Sagisag versus Ochoa, treaty, Your Honor, is equivalent to a statute, Your Honor, but it is higher than an executive agreement, but both, Your Honor, are subject to the supremacy of the Constitution.
So, under Philippine law, a treaty has the status of a municipal law, of a
Yes, Your
domestic
Honor.
law. So, if a domestic law passed by Congress is inconsistent with a later treaty, which will prevail?
Well, Your Honor, there are a few cases, Your Honor, that will give different answers to that question, Your Honor. In Gonzales, Your Honor, the approach was for the municipal law to prevail over treaty law. Whereas other cases posit the opposite, Your Honor. That is why we have a problem, Your Honor, with our jurisprudence, because there doesn't seem to be coherence with respect to how we treat treaties with respect and in relation, Your Honor, to statute.
So, you're saying that a treaty has the status of a domestic law, municipal law.
Yes, Your Honor.
Okay, and you're saying that if there are two domestic municipal laws that are inconsistent, it's the later law that prevails.
That's one approach used with the court, Your Honor.
And if domestic law, municipal law, is inconsistent with a later treaty, you're hedging your answer.
No, Your Honor. What I'm saying, well, Your Honor, my answer, Your Honor, is that the jurisprudence of the court has not exactly been very helpful in that question because it has ruled at some point that the later law will be supreme over a treaty, while in other cases, Your Honor, the opposite is the resolution or conclusion of the court, Your Honor. But in Sagisag, Your Honor, I think it's very clear that there are several provisions there, or several, a discussion by the court where it said there are certain principles that must be followed, Your Honor. And in fact, I think in Sagisag, the approach was that a treaty, if it's later, must supersede, Your Honor, a municipal law that deals with the same
that's
subject
the
matter.
latest ruling.
Yes, Your Honor.
Okay. Now, we have a lot of tax treaties, and tax treaties are concurred in by the Senate, correct?
Yes, Your Honor.
And these tax treaties carved out exceptions under the National Internal Revenue Code, correct?
Yes, Your Honor.
We have extradition treaties, correct?
Yes, Your Honor.
And they carve out exceptions under the criminal laws, correct?
Yes, Your Honor.
And we have the Visiting Forces Agreement.
Yes, Your Honor.
The Visiting Forces Agreement carved out exceptions on criminal jurisdiction for U.S. Military personnel here.
Yes, Your Honor.
So, a treaty can amend a prior law, correct?
Yes, Your Honor.
And we have laws like that here.
Yes, Your Honor.
And the tax treaties have been applied by this court, correct?
Yes, Your Honor.
And the Visiting Forces Agreement has been upheld by this court, correct?
Yes, Your Honor. In many cases, Your Honor, beginning
And
with Lim,
that
Your Honor.
agreement, the Visiting Forces Agreement, has carved out exceptions on criminal jurisdiction for.
Yes, Your Honor. In
Yes, military
Nicolas, Your
personnel.
Honor, in
So-
Bayan Muna.
So would you say that we have enough jurisprudence that a treaty, a later treaty, can amend a prior law?
Very well, Your Honor.
If it can amend a prior law, that means if there's inconsistency, the later treaty will prevail, correct?
Agree, Your Honor.
Isn't that the rule now?
As I said, Your Honor, that's the rule now in Sagisag versus Chowa, Your Honor.
Okay. Now, the President's duty is to faithfully execute the law. Now, you said that a treaty has the status of a law.
Yes, Your Honor.
So, the President has to faithfully execute a treaty, correct?
Agree, Your Honor.
And to faithfully execute a treaty does not mean that he can abrogate the treaty, correct?
Yes,
Because
Your
you
Honor.
are sworn to execute the treaty, to implement the treaty, you
Yes, Your Honor.
cannot obviously repeal the treaty yourself, correct?
That's correct, Your
You
Honor.
cannot abrogate it, correct?
Yes, Your Honor.
You cannot do anything that will prevent the implementation or execution of the treaty, correct?
Correct, Your Honor. According to the treaty clause, Your Honor, treaty becomes Philippine law by the doctrine of transformation, Your Honor.
Yes. So if it's a law, then if it's a later law, it will prevail over a prior inconsistent law, correct?
Correct, Your Honor.
So the President, being sworn to faithfully execute a treaty, cannot withdraw a treaty by himself, correct?
That's our position, in fact, Your Honor.
Okay. A treaty has to be approved by how many votes in the
Two-thirds
Senate?
vote of
Two-thirds vote.
the Senate, Your Honor.
If can the Senate withdraw the treaty by majority vote?
No, Your Honor, because it's clear in the language of the Constitution, it has to be two-thirds vote.
Does
Your
it
Honor.
say that that the Senate can withdraw a treaty by two-thirds only?
It says there, Your Honor, that well,
It needs to be approved by two-thirds vote, but
Yes,
there
Your
is
Honor.
no provision saying that approval can be withdrawn by two-thirds vote only.
That's correct, Your Honor, because the language only says that the treaty or international agreement is only given, may only be valid, may have validity and become effective on the vote by the Senate of two-thirds.
Okay,
of its members.
supposing a treaty is approved by two-thirds vote of the Senate, that's a law, correct?
Yes, Your
Municipal
Honor.
law. Later on, Congress, both the House of Representatives and the Senate, will pass a law repealing that treaty by majority vote only of both houses. Will that be effective repeal of the treaty? Because you said it's the prior act that will prevail. So a later law can repeal a prior treaty, correct?
Yes, Your Honor. I think
So-
that is the holding of the decision. of the
The
court in one
treaty
cases, Your Honor.
concurred in by the two-thirds vote of the Senate can be repealed by an ordinary law, correct?
Because under our jurisprudence, really that is the status of a treaty, Your Honor. It's a municipal law, Your Honor.
So it does not require two-thirds vote of the Senate to repeal a treaty,
If that is an act of Congress, Your Honor.
an act of both
Yes, Your Honor.
houses.
Yes, Your Honor.
Okay. Now, there is a provision also in the Constitution that tax exemptions can be granted only by majority vote of all the members of Congress. Remember that?
Yes, Your Honor.
So Congress cannot grant a tax exemption unless all the members, majority of all. Now, what is the requirement for the passage of a law in the House and the Senate? What is the required majority?
It's just majority, Your Honor. A majority, Your Honor.
Majority of what?
Of the members of each House, Your Honor, voting separately, Your Honor.
There are 24 members of the Senate.
Yes, Your Honor.
Now, what is the quorum?
The quorum, Your Honor, is a simple majority, Your Honor.
Simple majority,
Yes, Your Honor.
therefore, is
Uh,
13.
It's 13, Your Honor.
What does the Constitution say? What is the requirement to do business?
Quorum, Your Honor, is a requirement to do business.
To approve and to approve anything. The quorum, what is required? So you have a quorum of 13, it can act now.
Yes, Your Honor.
As a
For
Senate.
as long as it is
So
a
if a
quorum,
resolution is introduced, how many votes is needed out of the 13?
just a majority, Your Honor.
A majority of the 13.
Yes, yes, Your Honor.
So you need only how many votes? 7 votes.
7 votes, Your Honor.
So 7 votes in the Senate can pass law if the quorum is only 13.
Yes,
You're
Your
saying that. Is that correct?
Yes, Your Honor.
So when a law is passed repealing a prior treaty, you don't even need two-thirds, you don't need a majority of all the members, you need only a majority of the quorum. Is that
Yes, Your
correct?
Honor. Yes, Your Honor.
So you agree with me that for the withdrawal for the repeal of a treaty, there is only a majority required if both houses act on it.
Yes, Your Honor, because that's a separate procedure,
Okay.
Your Honor.
Let's go now to the Senate alone. Can a majority of a quorum in the Senate withdraw the treaty?
No, Your Honor, because the requirement, Your Honor, in the Constitution is the two-thirds
Is
vote,
it
Your Honor.
required there? Is there a requirement?
Because that's
But
the implication, Your Honor,
But
of
the Constitution says a majority of a quorum can do business.
that's only as to doing business, Your Honor. But
They can also pass a law, majority of a quorum. You just said it.
yes, Your Honor, but there's a specific requirement, Your Honor, in the Constitution. It's the
For
vote of
approval.
two-thirds. That's also the reverse is also true, Your Honor. That's our
But
position,
you
Your Honor.
mentioned earlier that there is a qualified majority to pass a tax exemption. But to withdraw that tax exemption or to repeal that, you need only an ordinary majority, a majority of a quorum.
Yes, Your Honor.
So if the Constitution provides a qualified majority to approve it, but to repeal that act, you need only a majority of a quorum, then you have to apply that principle to treaties.
But in our case, and our position, Your Honor, is that in the Constitution, the implication, Your Honor, of having a treaty, the treaty becoming valid and effective by two-thirds vote of the Senate, Your Honor, is the same principle that should be applied, Your Honor, with respect to withdrawal from a treaty, Your Honor.
Is there a difference between approval and withdrawal of a treaty?
Well, yes, Your Honor, because they are different procedures, Your Honor.
So in approval, it's an act of the President concurred in by two-thirds vote of the Senate.
Yes, Your Honor.
And in withdrawal, you're saying it's an act of the President and concurred in by the Senate,
Yes,
two-thirds
Your Honor.
vote of the Senate. But the House, the Congress itself, by ordinary legislation, can also repeal that treaty, withdraw, repeal that law,
By passing a law that
or an
is,
ordinary law,
yes, an ordinary law.
which means it can be passed by a majority of a quorum.
Yes, Your Honor.
In the House, assuming you have 300 members, majority is 151. So a majority of 151 is enough to pass that bill in the House, correct?
Yes, Your Honor. That's correct.
So where is the symmetry there? You're saying that two-thirds vote to approve a treaty by the Senate, but to withdraw, you need also two-thirds?
Well, the symmetry there, Your Honor, is that precisely, Your Honor, in the Constitution, the design is that for approving, for approval, or for the concurrence of the Senate to a treaty, it has to be by two-thirds vote, Your Honor. And the silence there, Your Honor, of the text does not mean that the converse cannot be said as a principle that's also applicable. It's actually, Your Honor, that the Constitution clearly states that the act of withdrawing from a treaty is not the sole province ceases to be the sole province of the President, because in the concurrence to the treaty, that action has been shared with the Senate, Your Honor.
Under our Constitution, general principles of international are automatically incorporated as part of the law of the land, correct?
Yes, Your Honor, under Article 2.
There's no need for Senate approval. But for a treaty, there has to be Senate approval, correct?
Yes, Your Honor.
So we follow the incorporation doctrine insofar as general principles of international are concerned.
Yes, Your Honor.
But for treaty law, we follow transformation. It has to be transformed by an act of the Senate.
That's correct, Your Honor.
How about in the U.S.? What do they follow? How do they automatically incorporate into domestic U.S. law general principles of international law?
Well, in theory, yes, Your Honor.
They do?
Pardon, Your Honor.
They do? They follow the incorporation doctrine?
Well, given, Your Honor, in some cases, Your Honor, if I recall my international law as applied by the U.S. Supreme Court, Your Honor, the history, Your Honor, at least of the U.S. Supreme Court, is that in the early days, Your Honor.
Yeah, but what is the latest now?
But
The
right now, Your
Medellin
Honor,
versus Texas. What is
yes,
the
but
ruling?
in Medellin versus Texas, Your Honor, the Supreme Court has adopted a test, Your Honor, for the acts of the President with respect to foreign relations, Your Honor. And I think, Your Honor, in Medellin versus Texas, the rule now taken by the Supreme Court, Your Honor, is that if the acts of the President, Your Honor, is at its strongest when it is covered by an act of Congress. It's at its lowest when it has nothing to stand on other than the decision
No, my
of the
question
President,
is,
Your Honor.
under Medellin, if the President signs a treaty, does it become U.S. law without Senate advice and consent?
No, Your Honor.
Okay, it does not. The President signs a treaty and there is advice and consent by the Senate. Is that a law now, domestic US
Yes, Your
law?
Honor. That's the Sablochi Act, Your Honor.
But that's not Medellin versus Texas. Medellin
That's-
versus Texas says there are only two ways to make a treaty domestic U.S. law: when Congress adopts implementing legislation, or when the treaty provides for is self-executory and it is ratified as self-executory.
Yes, the case on Sablochi Act, Your
So
Honor.
what I'm saying is, do we follow U.S. law here in the Philippines with respect to ratification of treaties?
Well, according to Pimentel, Your Honor, ratification is an act of the President, Your Honor, which we did not agree because we were the petitioners in that case, Your Honor, and we lost that case. But that's the rule right now, followed by this court all the way to Sagisag versus Chowa, Your Honor.
Okay, that's all, Counsel. Thank you.
Thank you, Your Honor.
May we call on Attorney Santiago? Good Good afternoon,
afternoon, Your
Attorney
Honor.
Santiago. Just a
Good
few follow-up questions from the questioning of Justice Leonen. This petition was filed because the President bypassed the Senate and did not seek its concurrence of its decision to withdraw from the Rome Statute. Is that correct?
Yes, Your Honor.
If the Senate went to the President, you think, I mean, if the President went to the Senate, would the Senate have concurred with the President's decision to withdraw from the Rome Statute?
I wouldn't be prepared to speculate on that, Your Honor, if the Senate would concur as to the withdrawal, Your Honor. But if I may also, Your Honor, our petition is based twofold, Your Honor. One is that it is our position that there was no concurrence with regard to the withdrawal, Your Honor. But alternatively, Your Honor, we also say that the withdrawal, the reason for the withdrawal itself is arbitrary, capricious, and whimsical, Your Honor.
But what do you think is the sense of the senators? Are they amenable to our withdrawing from the Rome Statute, from being a member state of the ICC?
Your Honor, if we will base it on the petitioners of the other petition, Your Honor, I doubt that they will get 2/3 vote to concur as to the withdrawal, Your Honor.
So you're saying that about more than majority of the senators would oppose the withdrawal?
I am not in a position to say that more than majority will oppose, Your Honor, but I think it is based again on the petitioners in the other petition, Your Honor. I don't think that 2/3 would be able to be gathered to concur as to the withdrawal of.
How many
the Rome
senators signed the Senate Resolution 289? That's expressing their sense, no, of their disappointment or their sense that the Senate should have been consulted.
We will look into it, Your Honor.
I beg your pardon?
We will look into the number of senators who signed the resolution, Your Honor. I am not in a position. I'm not sure how many senators have signed, Your Honor. But
And whatever happened to that? What was that adopted by the Senate? I mean that Senate resolution. Whatever happened to that Senate resolution? Was it even transmitted to the President?
I have no information whether it has been transmitted to the President, Your Honor.
So you're not, you don't know what the status of that Senate resolution?
That Senate resolution was not passed, Your Honor, because there were 13 senators in favor of the resolution, Your Honor. And
It was not passed.
it was not passed, Your Honor. 13, according to my colleagues, Your Honor.
And so the reason that it was never transmitted to the office of the President. And instead,
probably,
what you did was to just file this petition before us.
No, Your Honor. Our petition is independent from the action of the Senate, Your Honor. Again, Your Honor,
But you're
even
representing the senators.
we are not. I'm sorry, Your Honor. We are.
No, well,
our group is not representing the senators, Your Honor.
But there's is it Attorney Bagares who's representing the senators?
No, Your Honor. The three of us are representing the Philippine Coalition for the International Criminal Court and other individual petitioners, Your Honor.
Who is representing the senators here?
There is a representative of the senators here, but no counsel, Your Honor. No counsel has appeared before for the senators, Your Honor.
So anyway, because it's all over the papers, no, that the senators are feeling, they feel so strongly about being bypassed that their concurrence to the withdrawal was not sought by the Office of the President. So, anyway, well, it's clear now that so a while ago earlier, you were mentioning, attorney, that you were representing the Senate.
No, Your Honor.
No, I mean, I'm referring now to Attorney Coromina. Yeah. So you're here as may I know you're standing here? What?
Your Honor, I am here simply to first to find out what was the court's decision on the senator petitioner's resolution filed last Thursday, which the court then informed us of at the beginning of this session. And then I am only authorized to then read dependent on your decision of the court.
Okay. Thank you for that clarification. Thank you, Attorney Santiago. That's all.
Thank you, Your Honor.
Justice Bernabit.
Can I please call Attorney Baragas?
Good afternoon, Your Honor.
Attorney Baragas. Under the Constitution, does the court have the power to review the government's reasons for entering into or withdrawing from a particular treaty?
Well, Your Honor, that is a power granted by Article 8 of the Constitution, Your Honor, that it may review cases involving the constitutionality of a treaty, international or executive agreement, Your Honor.
But can the courts inquire into the wisdom of the President's
Only if there's
exercise of
a grave
discretionary
sorry, Your
power?
Honor. Only if there is a grave abuse of discretion, Your Honor. And if the act of the President, Your Honor, is against the Constitution, the provisions of the Constitution, Your Honor.
Now, in the case of Pimentel versus Executive Secretary, which also involved the Roman Statute, the court remarked, and I quote, that it is within the authority of the President to refuse to submit a treaty to the Senate, or having secured its consent for its ratification, refuse to ratify it. So if the President has the final say on treaty ratification, can it not be inferred that the President has also the final say in withdrawing from a treaty?
Thank you for the question, Your Honor. The difference in Pimentel, Your Honor, is that in that case, Your Honor, the treaty was not yet submitted to the Senate for its concurrence, Your Honor. That is why the court said that it is outside the province of the court to command the President to do that, because that would intrude into the foreign policy prerogatives of the President. While in this case, Your Honor, there was already such a concurrence. And the issue here, Your Honor, is whether or not the President may withdraw that treaty concurred in earlier by the Senate without the Senate's concurrence, Your Honor.
All right. Can the President suspend the performance of its treaty obligations with another state on the ground of national interest or national security?
Well, Your Honor, as stated earlier, Your Honor, that would be tantamount to a violation of the oath of office of the President, Your Honor, because treaty, Your Honor, has the status of a law, and the President is, in fact, mandated by the Constitution to enforce the law, Your Honor, unless there are grounds that may be invoked by the President. But my answer, Your Honor, would be it cannot be done summarily by the President, Your Honor. It must go through the procedures and processes outlined by the court precisely for such situations, Your Honor.
Wouldn't you consider that as part of the power to execute the law?
Well,
or at
yes,
least part of the residual power of the President?
it is a power that's not unlimited, Your Honor. Because even in Sagisag, Your Honor, this court said that the foreign policy prerogatives of the President is not absolute, Your Honor. And there are limitations that are given by the law and by the Constitution to the exercise of the power of the President in regard to foreign policy questions, Your Honor.
No, you said that a treaty is considered a law.
It has the status of municipal law because it's, according, Your Honor, to the Constitution, once it passes the concurrence of the Senate, it is transformed into Philippine law without any further requirements, Your Honor.
So you consider the Rome Statute as a law.
Yes, Your Honor. It became Philippine law by the concurrence of the Senate, Your Honor.
And therefore, it should follow the same procedure in passing or repealing statutes.
Yes, Your Honor. That's our position, Your Honor.
So if a statute is needed to withdraw from a treaty, is it correct to say that the Congress can terminate a treaty even without the consent of the President?
Yes, Your Honor, because the design, Your Honor, in Article 7, Section 21 is precisely that, Your Honor. That the power, Your Honor, to determine whether or not the Philippines will become bound to a treaty belongs to the Senate, Your Honor, and not to the President. The President's power, Your Honor, is only with respect to negotiations and ratification of the treaty. That's what Pimentel says, Your Honor. But with respect, Your Honor, to binding the President to the effect of a treaty, that belongs solely, Your Honor, to the Senate and nothing else, Your Honor.
Based on your recollection, was there any other time in our nation's history when a president unilaterally withdrew from a treaty?
As far as I remember, Your Honor, this is the first time. That is why this is a case of first impression, Your Honor.
So if there is no standing judicial interpretation as to whether or not the president needs to obtain the Senate's concurrence before withdrawing from a treaty, and there is no actual provision in the Constitution governing treaty withdrawal, how can you attribute grave abuse of discretion on the part of the President when he filed a notice of withdrawal with the United Nations?
Well, for many reasons, Your Honor, that we have outlined, Your Honor, in our petition. Number one, contrary to the President's statement that the Rome Statute is not published, Your Honor, according to the Doctrine of Transformation, there's no need for publication. And in fact, Your Honor, the respondents themselves admit that the core elements of the Rome Statute have been republished, Your Honor, in the IHL Act, RA 9851, among other reasons, Your Honor.
Now, according to the, you may or you may not answer this involves the Senate. According to the OSG's comment, Senate Resolution number 289, entitled Resolution Expressing the Sense of the Senate that termination of or withdrawal from treaties and international agreements concurred in by the Senate shall be valid and effective only upon concurrence by the Senate, has not been approved by the Senate and has actually been shelved for further study. The OSG further claims that the Senate deliberations on the said resolution further amplify the divided sentiment within the Senate, thereby demonstrating the lack of petitioner senators' lack of standing. Now, in light of the OSG's statement, can you confirm if there is as yet no official issuance by the Senate as a body formally asserting its shared authority over treaty termination?
That is correct, Your Honor. It did not muster enough votes because Senator Pacquiao actually objected to it, Your Honor. But having said that, Your Honor, the answer to that question, Your Honor, is Marbury versus Madison. It is not the province of the Senate to interpret and say what the law is. It's the province of the courts. That's why we're here, Your Honor.
But since the Senate has not asserted its prerogative to act, do you think the lack of any formal resolution coming from the Senate regarding its treaty termination power renders this case premature?
Your Honors, our position, Your Honors, is that the interest of the petitioners, although it is bound with that of the Senate, is also independent, Your Honor, because we're asserting, the right to public participation of the petitioners. Aside from the fact, Your Honor, that as my colleague has been explaining, Your Honor, that there is a violation of the right to effective remedy that should be afforded by the government to every citizen, Your Honor.
Okay. Thank you very much, Counsel.
Thank you, Your Honor.
Just quick questions. Attorney Bagares.
Good afternoon, Your Honor.
Now, when we enact a law, it is a joint act of law of both houses and the President. Is that correct?
Yes, Your Honor, because the President signs the law, Your Honor.
and that if the President does not act, in other words, the bill comes from both Congress, from both houses, then it goes to the President either to approve it or to veto it.
Yes, Your Honor.
If it does not act within 30 days, then
Becomes law, yeah.
it is automatically
Yes, Your
deemed approved. If he vetoes it, then it may be overridden by Congress.
Yes, Your Honor.
Now, in treaties, do you think that treaties is some sort of sui generis? Because the treaty becomes a law only with the concurrence of Senate. It does not pass through Congress. Do you get my point?
I agree, Your Honor, in that sense. Although it does pass through Congress to the Senate, Your Honor, as dictated by the Constitution, Your Honor.
Because when it is a domestic law, it can only be amended and repealed. It can be amended and can be repealed. Domestic law, I'm referring
Yes, Your Honor,
to
that's
domestic
correct,
law.
Your Honor.
Okay. So if you want to change or amend a domestic law, you have to go back to Congress and then follow the same process, right?
That's correct, Your Honor.
In treaty agreement, because it does not pass to the lower house, it only goes to the Senate for ratification. It is sui generis.
Precisely, Your Honor. That is why we are saying, Your Honor, that the Constitution must be strictly followed, Your Honor, with respect to the procedures that are taken.
I get
Yes, Your Honor.
Yeah, I understand your point. The treaty goes to the Senate and for ratification of the Senate. Then the treaty becomes part of the law of the land.
No, Your Honor, it becomes part of the law. Yeah, that's correct, Your Honor, by concurrence, Your Honor, because according to Pimentel, Your Honor, ratification belongs to the office of the President. But it becomes law of the land upon concurrence, Your Honor, of the Senate.
Concurrence of the Senate.
Yes, Your Honor.
So it becomes a part of the law of the land.
Yes, Your Honor.
Yeah. Do you think that the Constitution does not provide for any provision that in case of withdrawal, it should go to the Senate? Because this is a sui generis lawmaking power, is it not? It's not that may be the reason why there is no need to provide in the Constitution that withdrawal by the President should also be with the concurrence of the Senate, because this is not the same as a domestic law.
Well, Your Honor, my answer would still be the same, Your Honor. Because that has always been the history, Your Honor. If you follow the history of treaty making in the Philippines, Your Honor, from 1935, Your Honor, it has always belonged to Congress, to the Senate, Your Honor. The only difference there, Your Honor, is that in the 1970 Constitution, the vote was reduced to a majority, I think, Your Honor, and certain exceptions were given for the President to decide outside of the checks and balances provided by the Senate. That was returned, Your Honor, in 1987. And that has always been the case, Your Honor, as far as the legislative history of treaty making in the Philippines is concerned, Your Honor.
Okay, thank you, Counsel.
Counsel? Yes, Attorney Bagares.
Good afternoon, Your Honor.
The Senate Resolution 289 has not been passed,
It
correct?
has not been passed, Your Honor.
Okay, and therefore, it is pending, correct?
If I recall it correctly, Your Honor, the word is that it was shelved for further study, Your Honor.
Okay, so both the Senate, the President, the House, this court can read the Constitution. Is that not correct?
That's correct, Your
The
Honor.
only difference is that the Supreme Court has the final say, correct?
Yes, on the interpretation of the law and the Constitution, Your Honor.
Yes,
That's
and when
correct.
the Supreme Court makes an interpretation of the Constitution, that's it, correct?
That's correct, Your Honor.
Yes, and the Supreme Court cannot be impeached on the basis of their interpretation of the law. Is that correct? I withdraw that question.
Thank you, Your Honor.
But the point there is, because all the bodies can read the Constitution, might it not be better for this court to wait until the Senate does its own reading of the Constitution so that as a political body also seized of the opportunity to read the provisions of the Constitution, this court can properly differ, correct?
Well, that's really our problem, Your Honor, because
Especially
Time
because
speaking, Your
this
Honor.
court may not want to become the judicial dictator of this country, correct?
Well, of course-
Overextending its power into realms which are which might be political in nature rather than legal. Is that not correct?
Well, not necessarily, Your Honor. The reason why we're here, Your Honor, is precisely because, Your Honor, time is of essence. And on March 17, 2019, Your Honor, the withdrawal becomes effective. That's why we're here, Your Honor.
No, the
And,
withdrawal was already given, correct?
yes, Your Honor.
Yes, and the President, you're asking us to issue a writ of mandamus for the President to withdraw the withdrawal. Is that not correct?
Well, that's one of the remedies, Your Honor. But our first remedy, Your Honor, is for this court to void the withdrawal, Your Honor.
Yes, which means, in so far as the International Criminal Court is concerned, how will it be communicated?
It can also, like what happened, Your Honor, in South Africa, it was another letter, Your Honor, that was
Well,
communicated.
are we a colony of South Africa, by the way?
No, Your Honor, but I'm just saying, Your Honor, that the procedure is the same, Your Honor. It's also another note
Yes, but
verbal.
that's South Africa. They have their own constitution, correct?
Yes, Your Honor. And
Are
that's
you
it.
South African, by
No,
the way?
Your Honor.
You're not.
I don't look like one, Your Honor.
Yes, but it's a privilege to look like a South African once in a while.
Of course, Your Honor.
Like Alicia Vikander, for instance, is South African, if I'm not mistaken,
My
correct?
favorite band, Your Honor, is South African,
Yes,
Your Honor.
but in any case, the point there is we can only rely on our law, not that of South Africa or the UK, correct? And more importantly, not the United States, correct?
May I answer that, Your Honor? Because
Yes.
this court has, in many situations, actually looked to the jurisprudence of many countries, Your Honor, to establish rights afforded to citizens, Your Honor. In
Yes,
Luzon, Your Honor,
depends on the-
in
depends
Rubrico,
on the
Your Honor,
rights.
especially with respect
Excuse
to
me.
protection of rights.
I am asking a question.
Sorry, Your Honor.
And I hope you would listen to the
Yes,
question
Your Honor.
before you answer, because there's no point that you would interject or interrupt with your own answer without finishing the
I
question.
apologize, Your Honor.
Yes. Now, in other words, we are not a colony of South Africa. Is that not correct?
That's very true, Your Honor.
Yes. And therefore, insofar as this court is concerned, they can be persuasive, but they are not binding on us. Is that
That's
not
correct, Your Honor.
Especially because South Africa is a unicameral body and we have a bicameral body. Is that not correct?
Not necessarily, Your Honor.
And that the United Kingdom, which also was mentioned in your petition, has a parliamentary form of government and we have a presidential form. Is that not
We
correct?
agree that they have those forms of government, but we disagree, Your Honor.
Do they
as to
have
the-
a parliamentary form of
They
government?
have, Your Honor, we agree.
Yes.
But
I hope you just answer the question, because
Yes, Your Honor.
again, it wouldn't matter if you answer a different question for this
we submit, Your Honor.
justice. Okay.
We submit, Your Honor.
Your claim is that the president has the power of indirect legislation. Is that correct?
Yes, Your Honor.
So the president can legislate via a treaty with the concurrence only of the Senate, correct?
Oh, sorry, Your Honor, that's not what I meant. What I meant, Your Honor, is that by the act of withdrawal, unilateral
Because you
withdrawal,
said that a treaty has the effect of law without qualifications, and a treaty, as you said, is negotiated by the president through his or her alter egos, and the power of the Senate is simply to concur. Is that not correct? Therefore, in that sense, the president, from your constitutional theory, has the power of indirect legislation.
No, Your Honor. We disagree with that theory, Your Honor.
So, a treaty does not have the effect of law.
It has the effect of law, Your Honor,
Who
but that-
negotiates a treaty?
it's the President, Your Honor.
Who determines the content of the treaty?
It's the President, Your Honor.
When it submits it to the Senate, can the Senate amend the treaty?
No, Your Honor.
No, because that would mean that the President will again renegotiate the treaty, correct?
That's correct, Your Honor.
Yes, so therefore, the one that initiates and writes the content of the treaty is the President, correct?
That's correct, Your Honor.
And if the President, and if the treaty has the effect of law, the President has the power of indirect legislation, correct?
Well, I would disagree with that, Your Honor.
But that's the effect, correct? The President initiates and writes the content. Therefore, the President initiates the crafting and writes the content of that instrument which has the effect of law, correct?
That's correct, Your Honor.
Yes. The effect of treaty on domestic legislation, I think we need to qualify it a bit in order to be able to see how it relates to domestic law. Okay.
Very well, Your Honor.
International law has traditionally affected the relationships of two states, correct?
Yes, Your Honor.
Insofar as the subject matter of international law, especially of treaties before, it was only between state to state, correct?
That's correct, Your Honor, as far as classical
Yes,
international is
and
concerned. Your
therefore,
Honor.
whenever there is a treaty under the old conditions, it only affects the roles of the representatives of the state vis-a-vis another state, correct?
Yes, Your Honor.
Yes.
So the procedure, Your Honor.
And
that's
of
correct.
course, there is a possibility that the treaty will also affect the relationship of the citizen of another country sojourning or passing through the other state. Is that not correct?
That's correct, Your Honor.
In which case, therefore, that treaty has effect only because it commits the host state to the other state as to how it will treat the nationals from the other state. Is that not correct?
That's correct, Your Honor.
Yes. Okay. The third situation is when a treaty, like a human rights treaty, has the effect of committing a state with respect to its behavior with respect to its own citizens. Is that not correct?
Agree, Your Honor.
Yes. Tax treaties, are they of the first, the second, or the third kind?
Well, that concerns, usually tax treaties, Your Honor, has a bilateral nature.
Yes.
So it concerns, it
The
would
second.
concern simultaneously, Your Honor,
It affects whatever taxes that a boxer who boxes in the
Your
United
Honor.
States earns. Therefore, the treatment on income tax is dependent on the tax treaty. Is that not correct?
Yes, Your Honor.
VFA, visiting forces agreements,
That's correct, Your Honor.
also with respect to the second, correct?
Yes, Your Honor.
Now, with respect to the treaty that we are now considering, it has as its core obligations of the state vis-a-vis its nationals. Is that not correct?
Yes and more, Your Honor.
And with respect to that, it internationalizes 4 sets of crimes. Is that not correct?
That's correct, Your Honor.
Yes. It creates not only an obligation, but also liability for the first time, correct?
Yes, as a
Well,
permanent
for
court,
some,
Your
but
Honor.
not all.
Yes, Your Honor.
Yes. And these 4 sets of crimes are genocide. The second is war crimes.
Yes, Your Honor.
The third is crimes
Crimes
against
against
humanity.
Yes, Your Honor.
And the third one is the crime of aggression.
Yes, Your Honor.
Correct? Okay. So with respect to these 4, it means that a state is committing that it will not commit all of these crimes vis-a-vis its own nationals. Is that not correct?
Yes, that's one part of the Rome Statute, Your Honor.
Yes, the Rome Statute. That is the core part because International Criminal Court has a crime that it prosecutes, correct?
The most serious crimes, Your Honor.
Yes. Well, in terms of violations of the Geneva norms, it is not most serious but grave,
Yes, Your Honor.
correct?
And they have been...
in terms of The Hague, it is serious,
Yes, Your
not
Honor.
grave, correct?
That's correct, Your
In terms of crimes against humanity, it depends, correct? Yes, and there are, of course, the introduction lately in the Rome Statute of gendered crimes, which are not found in the Geneva Convention clearly or in the Hague Convention. Is
Yes,
that
Your
not
Honor.
correct?
That's
Okay.
correct, Your Honor.
So we have to qualify that. The point there is that here we have an obligation of the state vis-a-vis its nationals, correct?
Yes, Your Honor.
Yes. And with respect to the Rome Statute, before it was ratified by the Senate, there was already a law, correct?
Yes, 1 year
Yes.
before, Your Honor.
But there was a law.
That's the
Before.
RA 9851, Your Honor.
Yes, which your group helped in negotiating, correct?
That's correct, Your
Yes, and Republic Act 9851, therefore, is a law which gave the President more powers to accede to that particular treaty, correct?
Honor. Yes, Your Honor, because that's
Yes.
provided in Section 15
Now,
of
in
the law, Your
terms
Honor.
of Republic Act 9851, is there an acceptance of the procedures under the Rome Statute?
Yes, Your Honor, because the core crimes are there, Your Honor.
No procedures.
The procedures are not laid down
Not
in
laid down. In fact, there is only one specific provision in the Republic Act 9851 which refers to conventions and treaties which have already been ratified. Is that not correct?
That's in Section 15, Your
Yes.
Honor.
It does not mention the Rome Statute,
It
correct?
does not, Your Honor.
Republic Act 9851 was not the authorizing statute for the President to accede to the Rome Statute.
No, Your Honor, it's independent but complementary, Your Honor.
Yes. So if Congress wanted to bind the future generations with respect to the remedies under the Rome Statute, it could have as easily provided in Republic Act 9851. Correct?
Well, we believe, Your Honor, that in fact the Rome Statute.
Could it have provided in 9851 that the law authorizes the President and therefore accepts, the House and the Senate accepts that there will be complementarity, there will be an added layer in terms of these crimes?
Well, implicitly, that is provided for, Your Honor, in Section 15 and Section 2 of the law, Your Honor. Because there's an enumeration there, Your Honor, of so many obligations and
That's
arising
obligations.
from treaty, Your
I'm not
Honor.
referring to the obligations.
And-
There's a difference between substantive crimes and the procedure for the crimes. Is that not correct?
Yes, Your Honor.
For example, the triggers for jurisdiction. Correct?
Yes, Your
For
Honor.
example, Article 17. Correct?
That's correct, Your Honor.
For example, the acceptance of the crime of aggression.
That's
15,
correct, Your Honor.
15 bis, and the following, correct?
That's correct, Your Honor,
Yes.
because the Rome
So
Statute
there
does-
are provisions in the Rome Statute which were not included in Republic Act 9851. Is that not correct?
Yes, because they're not necessarily, Your Honor.
So Republic Act 9851 was produced through deliberations in the House and the Senate, correct?
That's correct, Your Honor.
And the House and the Senate did not produce the obligation on the part of the President to follow the rule on complementarity, gravity, office of the prosecutor, and the International Criminal Court,
I
correct?
disagree, Your Honor, because all over the law, Your Honor, you have
Show me.
those provisions, Your Honor.
Show me.
Well, Your Honor, let me refer the court, Your Honor, to
Where is the provision on gravity? The requirement of gravity before prosecution.
well, Your Honor, that is implicit in complementarity, Your Honor. And according to the
Show me. In Article 17, it is very clear under Article 17, Section D.
Yes, Your Honor, that's correct, Your Honor.
What about in 9851?
Because, Your Honor,
So the House and the Senate agreed that only these parts of the International Criminal Court will be covered by domestic legislation, correct?
because, Your Honor, that's also at the heart
Can
of
you answer my
complementarity.
question? The House and the Senate agreed that only these parts of the Rome Statute would be part of domestic legislation, correct?
That's correct, Your Honor.
There is no commitment under the domestic legislation to bind future generations as to another layer of a court. Is that not correct?
Well, we disagree, Your Honor, because with respect, Your Honor, to implementing
Where
the
in the
obligations,
law does it say that the President should bind ourselves to a additional layer?
Your Honor, may I refer, Your Honor, for instance, to the age to interpretation provided for in Section
Okay,
15.
read it. Does it say International Criminal Court? Does it accept another court?
Your Honor, Section 15 says that applicability of international law in the application of an interpretation of this act. Philippine courts...
Interpretation of the act, which means the text must already be there. Where is the text which actually says that it recognizes or allows the President to add another court?
Because, Your Honor, the RA 9851 is almost an exact copy of the Rome Statute, and the Rome Statute, Your Honor, is a
You're not
codification.
answering my question, you're eliding my question. My question is, where in that statute, so that we finish immediately, so
Very
that
well,
we
Your
can
Honor.
go home,
Eh,
okay?
It's not there expressly, Your Honor.
Not expressly.
Yes, Your
So
Honor.
the House and the Senate did not pass. The House, representative of the people, the Senate, elected at large, passed a law which did not include portions of the Rome Statute but copied the core provisions, correct?
That's correct, Your Honor.
Yes. So when the President removed the treaty or withdrew from the treaty, did it violate a law?
It did, Your Honor.
Which law?
Many
Statute.
laws, Your Honor, we are parties to so many treaties, Your Honor, for instance, the 4 Geneva Conventions.
Which
This
one?
one-
Which
The
convention?
4 Geneva Conventions, Your Honor.
The
we
Geneva
have-
Convention.
Yes, and
Have we withdrawn from the Geneva Conventions?
we are not, Your Honor, but all of these
Have we
conventions...
withdrawn from Protocol 1 of the Geneva
Your Honor.
Convention of 1949? Have we withdrawn from Protocol 2 of the Geneva Convention?
No, Your Honor, but our
Have we
answer...
withdrawn from the Hague Convention of 1907?
No, Your Honor.
So, what are you saying? We have also withdrawn from the Geneva Convention? Are the provisions of the Geneva Conventions already in Republic Act 9851?
Yes, Your Honor.
Did we withdraw 9851?
Well, that is not our
So be
answer, Your
careful,
Honor.
Counsel. Don't Don't do what a law student does. You answer the question.
We did
Okay.
not, Your Honor.
The question is, here we have a law passed by the House and the Senate. The House and the Senate, through a law, decided that only these portions of the Rome Statute will bind the Philippines. Correct?
That's correct, Your Honor.
Only by treaty did we add certain
Yes,
other
Your Honor.
things.
That's correct, Your Honor.
With the President withdrawing from the treaty, did the President violate this statute? Did the President withdraw from 9851?
May I qualify my answer, Your Honor?
Did the President
No, Your Honor.
No. So, he did not.
It did not, Your Honor.
Yes. So, that's it. Thank you.
Thank
Justice
you,
Person-
Chief. May I ask Attorney Andres, so that you will also have your turn to earn your pay?
Good afternoon, Your Honor.
Yes, we are all very clear now that the language of the Constitution, particularly Section 21 of Article 7, relates only to ratification. Does not mention at all about termination or withdrawal of the state party from the treaty, of the Philippines from the treaty it accedes to. Although this may be more properly addressed to the senators or their representation, I wanted to ask this to your side so that we will be quite clear. There is a specific rule of the Senate regarding ratification.
Yes, Your Honor.
You're aware of that?
Yes, Your Honor.
That is Rule Roman numeral 36.
Yes, sir.
Particularly Section 101.
Yes, sir.
Okay. Do you remember that particular provision about the contents of it?
I don't really have a working
You don't have an
memory,
idea about it, but I have that rule now before me, and I don't see anything mentioned about termination or withdrawal, a procedure for that. What I see here is only a procedure for ratification.
Yes, Your Honor.
Are you aware of any other part of the rules of the Senate that would refer to termination or withdrawal?
I am not aware of
You
Your
are not aware. So am I right to presume that the Senate did not bother at all to incorporate any rule on termination or withdrawal from treaties because they knew they were not to be a part of that process?
Your Honor, we agree on the first part that factually there's really no provision on withdrawal. But we respectfully disagree, Your Honor, with the second part, that it's because the Senate believes it doesn't have a power to concur in the withdrawal, Your Honor. It's based on two grounds, Your Honor. First, Your Honor, is that it's really for this honorable court to decide what are the metes and bounds of the powers of the branches of our government, Your Honor. In fact, that has been elucidated in Angara versus Electoral Commission, Your Honor. Therefore, it's not really for the Senate to say that it has the power to withdraw from, it has the power to concur from a withdrawal by the President. Second, Your Honor, is that it's still within the power of this honorable court to decide whether or not there has been a grave abuse of discretion. It's our contention, Your Honor, that the withdrawal by the President without Senate concurrence was imbued with grave abuse of discretion because it violates Section 21 of Article 7. Third argument, Your Honor, is that we can argue actually from analogy. The analogy, Your Honor, is that there is, yes, Your Honor, Congress has plenary powers to pass laws, Your Honor. But in fact, Your Honor, the plenary powers of Congress is also with the act of the President. The President signs a law. And Your Honor, even if Congress wants to repeal a law by a later Republic Act, Your Honor, that also needs the concurrence, in a sense, by the President through the signing of a law that will repeal a previous law, Your Honor. We can actually use that analogy, Your Honor, for a treaty, Your Honor. A treaty has effect, it's valid and effective under Section 21 of Article 7 if the Senate concurs by 2/3 vote of all its members. So it is valid and effective. under our constitutional mechanisms, Your Honor. Hence, Your Honor, the reverse is also true, Your Honor. If the President withdraws from a treaty such as the Rome Statute, then it also needs, Your Honor, the concurrence by the Senate, 2/3 vote of all
Okay.
its members.
Let us presume that the persons, the people who wrote the Constitution, they had the best minds, they knew what the people wanted, they knew what to offer to the people to ratify, to accept in the plebiscite. Do you agree with my assumption?
Yes, Your Honor.
If they wrote in Section 21, Article 7 of the Constitution about ratification, why do you think they did not mention treaty withdrawal or treaty termination
I think
as
Your
requiring 2/3, a qualified vote of 2/3?
Yes, Your Honor. I think, Your Honor, because it's necessarily implied. If there's a power to enter into a treaty and it can only have validity and effect if there's Senate concurrence, then by necessary implication, Your Honor, the reverse
so
should also be true.
You want to tell me you are a verba legis lawyer?
Your
Or
Honor,
you are an interstitial lawyer?
I'm both, Your Honor,
You're
depending
both. Okay.
on the advocacy.
So maybe, no, I just wanted to pick your mind on this. The better guy to be picked on will be the senators. Thank you.
Thank you so much, Your Honor.
Can I have Attorney Bagares?
Good afternoon, Your Honor.
Good afternoon, Counsel. The Rome Statute provides for withdrawal. Does it specify which law will govern the withdrawal?
Well, it leaves, in fact, it leaves it, Your Honor, to the state party to decide so based on its own constitutional system, Your Honor.
So you agree that a valid withdrawal is determined by municipal law?
That's our position, Your Honor, from the point of view of the Constitution, Your Honor.
And our problem here is that under your claim, municipal law is Article 7, Section 21.
That's correct, Your Honor.
But as pointed out, and there were slides a while ago, all it says is concurrence by 2/3. The text of 21 doesn't say what to do if there is a withdrawal, right?
It does not expressly state the procedure, Your Honor.
Let's agree first. It does not state it, right?
That's correct, Your Honor.
On the face of the text.
Yes, Your Honor.
So therefore, you are basing an argument not based on the text. Now, the government is arguing that precisely that 21 is not a textual support for your argument. But also, they cannot point to a provision which says that textually the President has the power to unilaterally withdraw from a treaty. Do you agree?
Yes, Your Honor.
And I think by the time I get to the government next week, hopefully, I am sure they cannot also point to the text of the Constitution which says the President can unilaterally withdraw from a treaty.
Yes, Your Honor.
That is why we have a legal issue. And a while ago, there was a question of, so how do we now divine the intent of the Constitution? Again, there are no debates in the Constitutional Convention.
That's correct, Your Honor.
Now, the Constitutional Convention was 1987, right?
86, Your Honor.
86, I'm
Yes, Your
sorry.
Honor.
When was the Goldberg case in the U.S.?
In the 70s, Your Honor.
In the 70s.
Yes, Your Honor. The time of Jimmy Carter, Your Honor.
Yes. So, again, what happened was there was an issue. This issue was already brought in the United States.
Yes, Your Honor.
Although the result is not definitive.
Yes, Your Honor.
So we cannot divine intent from the 86 proceedings, right?
That's correct, Your Honor.
So what I've been hearing from you repeatedly, you mentioned checks and balances,
Yes, Your Honor. Doctrine of separation of powers, Your Honor.
separation of powers. And the government's position, from reading the submission of the government, essentially is it's a presidential power based on the power of the president over the conduct of foreign affairs.
Yes, Your Honor.
Yes. Now, again, if we go by your checks and balances, if I look for the text, I cannot find it, but you are arguing checks and balances.
Yes, Your Honor. From jurisprudence, Your Honor.
From jurisprudence. In the same manner, if you look for a support for the position of the government, you cannot find it either. And so what I am suggesting, and this is why we have a difficult question, is I think the lines are drawn. On the one hand, you are arguing checks and balances. The government is arguing the powers of the president based on his foreign affairs power and the residual powers of the president.
That's correct.
And then now you mentioned jurisprudence. Now, on the one hand, what would support the government's view, if you, for example, go to U.S. presidents, is Curtis Wright.
Yes, Your Honor.
That is where the U.S. Supreme Court said the president is the
Chief Architect.
chief architect.
Foreign policy.
On the other hand, of course, in you cited, you have your position is Youngstown Steel.
Yes, Your Honor.
This is the opposite. So you have to help me out because I think that is where the lines are drawn. Essentially, the issue you are presenting to this court forces this court to make a decision, on the one hand, between checks and balances and the powers of the president. And then, of course, you have the Manglapus case.
Yes, Your Honor.
So when you do your memorandum, I would like you to focus on those because I think you have structural arguments on either side. There is no textual resolution to the problem. So it could be that how the court will decide will be a measure of where the court will weigh in. Is it checks and balances or is it presidential power?
Thank you, Your Honor.
Can I just have one question for Attorney Andres?
Good afternoon, Your Honor.
Good afternoon, Attorney Andres. Can you please have on the screen again your fourth submission?
Yes, Your Honor. The fourth submission, Your Honor, is really on the expanded certiorari jurisdiction. of the
No,
Honor.
before that, the
fourth submission, Your Honor, is an argument that since the withdrawal from the Rome Statute effectively abolishes the Filipino people's parallel means of enforcing their right to effective remedies.
yeah, can we have the
Yes, Your
slide?
Honor. There you are.
Can you have the slide before that?
Yes, the third argument, Your Honor, is that it's within the judicial power, which is to settle actual controversies involving rights.
Yes, can we go back to your next slide?
And this is the reference, Your Honor, to the expanded certiorari jurisdiction.
Well, you know, in your previous submission, because what I am leading to cut to the chase, is that you are asserting a right to effective remedies.
Yes, Your Honor.
Now, I understand you are anchoring that on international law.
Yes, Your Honor.
You are not anchoring that on the Philippine Constitution.
In fact, Your Honor, in the original slides given, we were actually arguing that it's also a constitutional right, Your Honor. But for brevity, due to time constraints, Your Honor, we actually forgone with that slide, Your Honor.
But this is very important for me. Which is which? Did you drop it because you don't believe anymore that it is founded on the Constitution, or you are conceding that it is founded on international law?
All right, Your Honor. First, Your Honor, we drop it, but we still believe, Your Honor, it's still our legal position that the right to effective remedy is a constitutional right.
And again, my question is, which part of the Constitution can you point to
Your
as
Honor,
a foundation for a constitutional right to effective remedies in codes?
Yes, Your Honor. I think the best textual support, Your Honor, is Section 1 of Article 3, that no person shall be deprived of life, liberty, or property without due process of law.
Where in that Article 1 does it say about, quote, right to effective remedies?
Your Honor, it might not say the right to effective remedies, Your Honor, but there can actually be an argument, Your Honor, by logic, Your Honor, since we have substantive rights. Those are the right to life, liberty, and property.
So it is not a right expressly or explicitly defined by the Constitution.
It's not explicitly stated in the text, Your Honor, but we can say, Your Honor, that actually all of the text in Article 3 of the Constitution, in a sense, Your Honor, creates a penumbra of right to effective remedies, Your Honor, using, Your Honor, the privacy rights as seen as constitutional right, Your Honor, in America, Your Honor.
Why is there a privacy right here?
Your Honor, it's also contained in Section 4, Your Honor, the right to privacy. But we're arguing, Your Honor, from analogy, since the logic, Your Honor, is that if there is a deprivation of the right to liberty, right to security, right to life, Your Honor, without due process of law, then, Your Honor, there should be essentially, by implication, a right to an effective remedy so as to address the deprivation of a constitutional right.
I understand your argument. I'm just saying it's not expressly or explicitly stated in the Constitution.
Yes, sir.
And you are arguing a constitutional right to effective remedies
Yes,
as a matter of constitutional law, independent of international law.
Yes, Your Honor.
And you are asserting that for the first time.
Yes, Your Honor.
In this case.
Yes, Your Honor.
And I am saying that from where I sit, that would be a different issue from your first ground. So maybe
Yes, sir.
cover it. Why should this court agree with you that there is a right to effective remedies as an extension of the right either to life or an extension of a liberty interest?
Yes,
because
Your Honor.
is there a support for your view, for example, in previous cases of this court?
I think, Your Honor, there are actually support, Your Honor, in jurisprudence by this honorable court, Your Honor.
Can you name them?
Your Honor, I think one, Your Honor, would be Secretary of National Defense versus the Manalo brothers. This is one of the first cases regarding the rule on the writ of amparo, Your Honor. And, Your Honor, in fact, it's actually a recognition by this honorable court that at that time, before the writ of amparo was issued, Your Honor, there were actually no effective remedies, Your Honor, with respect to extra legal killings
Now,
and
do
enforcement.
you realize that what you are trying to persuade this court is to declare a right to effective remedies as a fundamental constitutional right?
Yes, Your Honor.
Now,
we understand the implication.
If it is a right, it is a fundamental constitutional right, do you realize that the effect of that is beyond the police power of the court?
In fact, Your Honor, if you will argue that it's a fundamental human right, Your Honor, there will actually be a reverse of presumption, Your Honor. In fact, the withdrawal by the President without Senate concurrence would be presumed to be unconstitutional, Your Honor.
No,
based on
in
Ople
fact,
versus
the
Torres.
argument, if it is a fundamental right, and if we did not join the Rome Statute, you could have filed a mandamus case against the Congress to have a law to join the ICC, the Rome Statute.
Yes, we understand, Your Honor. In fact, it was the case of Pimentel versus Executive Secretary.
Well, Pimentel did not say anything about fundamental rights. All it
No,
said
Your Honor.
is there is it just ratification.
Yes, Your Honor.
So I am trying to frame now, because I have to decide also soon which arguments. So I understand, and I'm trying to frame it. Your side, they have a checks and balances argument. You have an argument on international law as a source of effective remedies, but you are arguing a constitutional, meaning Philippine constitutional fundamental right
Yes,
to
sir.
effective remedies.
Yes, sir.
Thank you, Counsel.
Thank you so much, Your Honor.
Justice Carpio.
Attorney Andres, I have some questions.
Yes, Your Honor.
The Constitution states that the state guarantees full respect for human rights. Does
Yes.
full respect include an effective remedy?
Yes, Your Honor, we agree that it should include an effective remedy because
Okay.
if there are no effective remedies, Your Honor, it will render all the
Then there
substantive
will be
human
no
rights
full respect.
nugatory.
It will be just a play of words.
Yes, Your Honor.
Okay. How is a statute or a law repealed?
Your Honor, if it's repealed, Your Honor, if Congress passes a law, Your Honor, that
So,
explicitly repeals it.
A prior law is repealed by a later law.
Yes, Your Honor.
Is there another way of repealing a prior law other than a later law?
None that I can think of as
There's
of now,
none.
Your Honor.
Does the Constitution say that an earlier law can be repealed only by a later law? Is there a provision?
No, Your Honor, there's no
none.
explicit
But
provision.
why are you saying that an earlier law can only be repealed by a later law when
Because,
the Constitution is silent?
yes, Your Honor, because it's actually an argument from silence, Your Honor. Even though there's no explicit provision in Article 7 and Article 6, Your Honor, on the legislative department with regards to repeal of a law, Your Honor, there's still that practice by Congress, Your Honor, that it can repeal
But
a
what I'm
previous
saying,
law.
if there are two laws that are irreconcilably inconsistent, which law will prevail?
It's the later law, Your Honor.
Later law. That's why the only way you can repeal an earlier law is to pass a later law that is inconsistent with that earlier law, correct?
Yes, Your Honor.
And you don't have to state that in the Constitution.
Yes, Your Honor.
So
And
how
it's-
do you repeal a treaty concurred in by the Senate?
how to repeal a treaty, Your Honor. As pointed out by Your Honor, there can be a statute that it's
Statute?
essentially
But
contradictory.
does it have to be stated in the Constitution?
It's not stated in the Constitution.
Because the Constitution does not say also how an earlier law is repealed, correct?
Yes, Your
Basic that if there are two laws that are inconsistent, it's the later law that prevails, correct?
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Justice, who? Justice Nobel Tiham.
Okay. Good afternoon.
Good afternoon, Your Honor.
My colleagues ask all the incisive questions. I will just ask the simple questions. When the instrument of withdrawal was submitted, this was accepted, correct?
Yes, Your Honor.
It was not rejected.
Yes, Your Honor.
It was not subject to a suspensive condition that it should bear the concurrence of the Senate.
Yes, Your Honor.
Hypothetically, assuming that the Senate passes a resolution revoking the withdrawal made by the executive department, and hypothetically, supposing the court, this court, issues a decision nullifying the withdrawal made by the executive department, which of these three instruments will be considered, do you think, by the ICC as a valid binding act of the member state? Is it the instrument of withdrawal submitted by the President, the Senate resolution, or the decision of the Supreme Court?
I think, Your Honor, based on international law, it's really the acts of the President through his political agents But we also like hasten to add, Your Honor, that acts of a state before the international sphere will only have binding effect if it's also in accordance with the internal law of that state, especially the fundamental law of the state with respect to a treaty. And that fundamental law, Your Honor, is precisely Section 21 of Article 7, Your Honor.
All right. And my last question, so that the other members of the court can ask questions. You were talking about analogy. Although the Constitution is silent on the vote required for withdrawal from a treaty, you said by analogy, if the act of the executive requires the concurrence of the Senate, then by analogy, it should require the concurrence or the ratification by the Senate if there is withdrawal. That is what you're saying.
Yes, Your Honor.
All right. So by analogy, if the President appoints a public officer and submits it to the
Yes.
Commission on Appointment
Yes, Your Honor.
for concurrence, are you saying that the President cannot fire that public official without concurrence from
Yes,
the
Your Honor.
Commission on Appointments?
I do understand, Your Honor, the force and power of that second analogy, Your Honor. But I think there's really a distinction, Your Honor, between the first analogy that this representation gave and the analogy of Your Honor with respect to appointments by the President. Because the power of the President when it comes to appointments, Your Honor, is actually the President is actually appointing, Your Honor, an alter ego, Your Honor. Hence, it's essentially an executive power, Your Honor, which is explicitly within the powers of the President.
A question. The accession to the Rome Statute, you consider it essentially an executive power?
It's essentially an executive power, but because of Section 21, Article 7, there's an intrinsic checks and balances provided by the Constitution through the Senate concurrence.
All right. Thank you.
Thank you, Your Honors.
Attorney Andres, can you put back the fourth submission again on
Yes,
the
Your
screen?
Honor.
Anyway, most of my questions have been answered already. I'm clarified in almost everything. But I just want to know if you are prepared for today's oral arguments. Screen. It talks about gross human rights violations.
Yes, Your Honor.
Do you know the number of drug addicts we have in the Philippines?
Your Honor, there's been estimates that it's amounting
So
to
you
millions.
don't know. So you don't know.
I don't know the specific number, Your
So
Honor.
do you know the number of gun holders,
I don't know,
loose
Your Honor.
firearms and license?
I don't know.
No.
Your Honor.
Do you know how many are in jail for drug offenses?
I also don't know, Your Honor.
How many pushers are there and how many drug lords are there?
I don't know.
So
the
you don't
number.
know?
Yes, Your Honor.
So we don't really know if there are gross human rights violations in accordance with the drug war because you don't have the statistics to even have a modifying effect what you mean by gross.
We
Is that
underst-
correct?
Yes, Your Honor. We understand the concern of the...
Yes,
of-
because if you divide 10,000 people by 100 million Filipinos, that's only 0.001%. 0.001 of the population. So I don't know if you're insisting if the tribunal will accept on the standard of what you mean by gross or grave.
I think, Your Honor, our legal argument is apart from any factual consideration, Your Honor, because it's actually established in international law that international crimes are gross human rights violations, Your Honor. And that's where we're arguing, Your Honor, from a legal standpoint, Your Honor, apart from the factual considerations, Your Honor. In fact, we have not made any factual allegations as to the number of those killed, Your Honor, with respect to the war on drugs, Your Honor.
Yes, but it's been established earlier that the courts are functioning. We have the courts to receive complaints. We have the police to address problems. We have lawyers to protect these people. We have all the laws to safeguard these people. So I don't see why there's a need to refer this problem to the ICC, because there is no utter failure of our judicial system in addressing these problems. That's why I'm asking for the statistics of how many are arrested, how many have been incarcerated.
But what I know of, Your Honor, is that the PNP has recognized that there are 4,000 deaths, Your Honor, under the war on drugs, which was even the subject of another petition, Your Honor, Sister Danyo versus PNP chief. And according to estimates of human rights organizations, there are about at least 14,000 deaths, Your Honor, with respect to the war on drugs, Your Honor.
So there's a disparity of 4 to 40,000.
Yes, Your Honor. In
So
fact,
that's why I'm asking you about the figures, because you come here, you state figures, but you just say it's estimate. So I wish you had the hard data so that we can analyze what is meant by gross violations.
In fact, Your Honor, if I may cite the appeals chamber admissibility case of prosecutor versus Jermaine Katanga, Your Honor. Jermaine Katanga, Your Honor, was the commander of an armed group operating in the east of Congo, Your Honor. And they actually, in one incident, Your Honor, that is the subject of an indictment before the ICC, there were 200 persons killed, Your Honor. And he was actually convicted, Your Honor, as an accessory to a crime against humanity by a mere killing of 200 persons.
This is in Africa.
This is in Congo, Your Honor.
Yes, Africa.
Yes, Your Honor.
Because in Africa, they have warlords, and they have tribal warlords. It's different from the Philippines. We have an effective PNP organization here in the Philippines, unlike in Congo or in Kenya or Nigeria. You talk about parallel means of helping the Philippines. So you're stating that the ICC is a parallel court, much to the embarrassment of our court system in the Philippines. Is that
really,
right?
No, really, Your Honor. Because I think, Your Honor, if I may be very personal, Your Honor, I had a misunderstanding of what complementarity is. I really thought that one can invoke the jurisdiction of the ICC if there is unwillingness or inability by the state party, Your Honor. But that is far from the truth, Your Honor. In fact, the ICC Appeals Chamber clarified, Your Honor, the understanding of unwilling or inability in the case of prosecutor versus Jermaine Katanga. The ICC Appeals Chamber has held, Your Honor, that in fact, Your Honor, it was an interpretation of Article 17 of the Rome Statute, which provides that the cases wherein a situation is inadmissible, Your Honor. And if I may just cite letter A, Your Honor, the case it's inadmissible where the case is being investigated or prosecuted by a state which has jurisdiction over it, unless the state is unwilling or unable genuinely to carry out the investigation or prosecution. It follows, Your Honor, that actually it should be understood using the first sentence. The first clause, Your Honor. The case, it's inadmissible if the case is being investigated or prosecuted by a state which has jurisdiction over it. Ergo, Your Honor, what if the case is not at all investigated and it's not at all prosecuted by a state party, Your Honor? Therefore, Your Honor, that inaction by a state party will actually make that case admissible before the ICC, Your Honor. So it changed my erroneous understanding of complementarity, Your Honor. In fact, it's not really a ladder, Your Honor. Complementarity is not a ladder wherein first you have to determine whether there's unwillingness or inability. In fact, it's a parallel road, Your Honor. Why? If a state party does not investigate or does not prosecute, then the ICC can deem that case admissible, Your Honor. Moreover, Your Honor, it's also a parallel road based on Section 17 of RA 9851. The second paragraph, Your Honor, because it provides there that in the interest of justice, the relevant Philippine authorities may dispense with the investigation or prosecution of a crime punishable under this Act if another court or international tribunal is already conducting the investigation.
All right. So if the police PNP director would ask the policeman to explain, is that already an investigation, or you want a real investigation?
No, Your
Because-
Honor. There
So,
should be a same test case, Your Honor. There should be the same situation, the same incident,
Aren't
same
they not
person.
asked to explain why somebody was got shot in a bypass operation? Aren't they not asked to explain and make the report?
In fact, Your Honor, it's our respectful contention, Your Honor, that there has been no investigation whatsoever, Your Honor. Because if there has been an investigation, based on the PNP Manual of Conduct, Your Honor, there should have been prosecutions, Your Honor. And there should be no presumption of regularity, Your Honor, in a police operation where there is actually the case where an accused or a suspect is killed, Your Honor. There's a reverse presumption,
So
Your Honor.
your complementary is that the international court can proceed even if there is a functioning court in the Philippines?
Yes, Your Honor. In fact, it doesn't state that there's a total collapse, Your Honor, of the judicial system, Your Honor. Not that...
My question now is, we're just a small country, the Philippines. It's just a small country. Do you think we will get justice in the United Nations?
Your Honor, it's our contention that we hope that we can also get justice in the International Criminal Court, Your Honor.
No, in the United Nations. You think there is justice in the United Nations?
I'll be very candid, Your Honor. In fact, with respect to the major powers, there's no justice because three of the major powers...
You have to remember, they have veto power
Yes,
in
Your
the
Honor.
Security Council. Any
Yes, Your
resolution passed by the United Nations, whether for the good of a country like the Philippines, it can be vetoed at any time by China,
Russia,
the United
US.
States, Great Britain, and France. There are
Precisely,
5 veto powers.
Yes, Your Honor.
So there's no justice there.
In fact, Your
Because
Honor, it's unequal.
they have no need to explain why they are going to veto any law or any action that will help the Philippines.
But
that's
that's-
why I'm so sad that we are insisting on international tribunals where the parameter of injustice is very blatant. It's very apparent that they have the veto power over anything in the United Nations. And that's why I cry a little now. Because we are insisting on foreign powers trying our people, sentencing our people, and they go scot-free. Russia annexed Crimea. China has annexed a lot of things. There is no freedom in China. There's no election. But here we are. We are exposing ourselves to total blindness to these Western ideals or international ideas when we have a functioning court.
In fact, Your Honor, I do agree, Your Honor,
You
with your
agree with me?
observation. Your Honor. In fact,
Yes.
the solution there is for China, the US, and Russia to be a state party to the ICC, Your Honor. So
In
that
fact, the problem with the ICC finding something wrong with the Philippines, it could lead to economic disaster. Because if we do not follow the ICC later on in the future, if they will make a decision against our leaders, they could just cut off our credit lines, they could cut off our visas, they could cut off our employment of our workers, which they have done to a lot of people, nationals of Russia, nationals of North Korea. See, the implication is down the road is very, very wide. You might be just looking at this short term, but if you look at the long term, I think maybe the government has used its intelligence well to see that this ICC participation may not augur well for the Philippines. It may be ominous for us to really stick to this when there is no really justice in the United Nations, because as you said, you agree, they have veto power over all the acts of other countries. Anyway, that's my only question.
Thank you, Your Honor.
Thank you.
So no more, Justice? No? I have just very few questions to Attorney Bagares, please.
Thank you, Your Honors.
This will be very brief. Ah, yes. You want to ask some?
May I have the last question? Okay.
Justice Joey Reyes,
May I
please.
proceed? Yes. This question or questions can be answered by any of the respondents or petitioners' lawyers. And this has something to do with the basis for the submission earlier made by you. Now, the submission was that a unilateral withdrawal is not valid and effectual from the point of view of constitutional law.
That's
now,
correct, Your Honor.
is that correct?
Yes, Your Honor.
All right. Now, may we know the basis for this statement?
Well, Your Honor, our basis is that first, Your Honor, it violates Section 21 of Article 7 of the Constitution.
Yeah, so-
Secondly, it's also a violation, Your Honor, of the doctrine of separation of powers. Those are our two main arguments, Your Honor, with respect to that submission, Your Honor.
All right. Let's limit our discussion or answer to Section 21.
Yes, Your
The
Honor.
unilateral withdrawal is not valid as it is contrary to Section 21. Is that it,
Yes, Your Honor.
Counsel?
Yes, Your Honor.
But as earlier clarified by my brethren here, my colleagues, it is very clear that Section 21 does not mention anything about withdrawal.
It does not, Your Honor.
Section 21 speaks only of concurrence.
That's correct, Your Honor.
All right. So, you also spoke about the withdrawal was done with grave abuse of discretion.
Yes, Your Honor. That's
Now,
correct.
how can there be grave abuse of discretion when there is no express provision regarding any withdrawal from a ratified treaty?
Our primary anchor for that argument, Your Honor, is the doctrine of separation of powers. Because you were saying, Your Honor, that the law...
Never mind the separation of powers.
Yes, Your Honor.
Let's look at, because you filed a petition, right?
Yes,
For
Your Honor.
certiorari.
Yes, Your Honor.
Meaning both petitioners.
Yes, Your Honor.
All right, so let's look at that. The main reason is grave abuse.
Yes, Your Honor.
Was there grave abuse of discretion committed by the President of the Republic of the Philippines in so withdrawing from the Rome Statute?
Yes, that's our contention, Your Honor.
Yeah, how can there be abuse of discretion then when there is no provision that is being violated?
Well,
Nothing.
our contention, Your Honor, is that precisely that provision in the Constitution, Your Honor, by analogy or by necessary implication, Your Honor, also requires a parallel procedure with respect to withdrawal, Your Honor. And second order argument, Your Honor, is that Senate Resolution 546 remains law, Your Honor, and as a law, it cannot be undone by the President, Your Honor.
I'm just trying to simplify matters, you know. If we have to grant or deny the pending request for writs, I think we can only center our points on the issue of grave abuse of discretion, because that is your petition, you see. So I just want to be clarified before we finally resolve this issue about grave abuse of discretion. There appears to be no grave abuse of discretion if we just look at Section 21. Now, another point, Counsel, how important is the Rome Statute to us, to the Filipino people? You mentioned that we Filipinos have the right to effective remedies. Are there no effective remedies available for those victims of human rights violations?
Well, Your Honor...
In the Philippines, are there not enough remedies available?
Your Honor, the jurisprudence of the ICC itself actually gives us some some idea, Your Honor, when there is unwillingness or inability, Your Honor. Inability, Your Honor, is not or unwillingness, Your Honor, is not established by, or the willingness is established by the theoretical situation where, given that courts are functioning, that there is a all the pillars of the criminal justice are in place. It doesn't mean that it's willing, because the measure really there, Your Honor, is actual prosecution. And the test, Your Honor, in a number of cases, Bemba, Katanga, cited by Attorney Andres, there's the case of Bagbo from Cote d'Ivoire. It's the test, Your Honor, same case and same subject, same conduct test. Meaning, Your Honor, that the persons being prosecuted would be the same persons that would be prosecuted by the ICC in case there is no prosecution in the domestic system. So that is the meaning there, Your Honor, of unwillingness. The test is same case, same subject, same conduct, Your Honor. In fact, I would agree with the court that there's, even though it's not really necessary that we have the Rome Statute as a basis, because theoretically, Your Honor, if we have 4,000 extrajudicial killings, if they are prosecuted for murder, Your Honor, 4,000 murders, that in fact would qualify as effective remedy, Your Honor. There's no need.
All right, let me cut you.
Under the jurisprudence of the Rome Statute, Your Honor.
Are there not enough courts that will handle all of these cases?
That precisely is the question, Your Honor, whether or not...
There are no enough courts that you will have to go to the International Criminal Court?
I think that's really the misunderstanding, Your Honor, because we're actually not saying you should go to the ICC. We're asking this court to make the system work, to make complementarity work, to make sure that our courts actually function. That's the very heart of complementarity, Your Honor. That's Article 17. And the test, Your Honor, for these cases is same subject, same case, same conduct. We may not prosecute for crimes against humanity, but if you prosecute murders, all 4,000, assuming that they are unlawful killings, Your Honor, that would be equivalent, in fact, to courts functioning, to courts being willing to prosecute gross violations of human rights, Your Honor. That is really, Your Honor, is the heart of the test of willingness of a state to provide effective remedy, Your Honor.
It is your position that there are no effective remedies available in our country.
We are not saying that, Your Honor.
What are you saying, Counsel?
What we're saying, Your Honor, is that under the Rome Statute, the principle of the complementary principle, if we refer, Your Honor, to the statement of the prosecutor, it's a preliminary examination. In fact, right now, Your Honor, at the stage of preliminary examination, it's just a universe of possible cases. There's no specificity, Your Honor, because the function of preliminary examination is precisely for the prosecutor to coordinate with national authorities to see if there are effective prosecutions, Your Honor. And that is where the misunderstanding lies for many of us, Your Honor. That complementarity does not mean that we'll go to the ICC and the ICC will solve the problems. No, Your Honor. We want solutions within our courts. We want complementarity to work. We want to see the same subjects, the same case, the same conduct being prosecuted, being pursued by our courts, Your Honor. That is the meaning, Your Honor, of willingness in Article 17, Your Honor.
And then seek remedies from our local courts.
Yes, Your Honor. That, in fact, is our purpose, Your Honor, for filing this case.
There is then no need for the Rome Statute.
There is a need, Your Honor, because the complementarity requires that there is a third-party body that will ensure that we are doing our jobs, Your Honor, that we are cooperating with the procedures provided in Article 87, for instance, of the ICC, Your Honor. That is at the heart, Your Honor, of Article 17. We are not actually saying, Your Honor, that we should go to the ICC. What we're saying, Your Honor, is to allow our courts to work, to allow our prosecutors to actually perform their duty to provide effective remedy if and when, in fact, these cases constitute unlawful killings. And we are, in fact, if we look at the statement of the prosecutor, Your Honor, no, she does not mention anyone. She refers to a situation. Because that is really the stage of preliminary examination. There is no case yet. She is just trying to see if we are implementing the provisions on complementarity, Your Honor. And this has been the holding of the ICC in many cases. We mentioned Katanga, we mentioned Bemba, we mentioned Bagbo and Cote d'Ivoire. These are the cases that are at the heart of what it means to have complementarity, Your Honor. We do not want the ICC to work, Your Honor. We want our courts to work. That is why one of the anchors to our petition, Your Honor, is for complementarity to work, for us to comply with our obligations. That's also what is stated in Bayan Muna v. Rumulo, that we are bound by our obligations under the treaty Because we are a state party, Your Honor. And that's why, Your Honor, it's a grave abuse because there's irrationality in the withdrawal. Because no one is even a target yet as a suspect. It's just a preliminary examination. And under the rules of the ICC, it's only considering a situation. We only go, Your Honor, to that position if there is already a decision on the part of the ICC to move to preliminary investigation, in which case the prosecutor will ask a pretrial chamber to authorize that phase of the process called preliminary investigation, Your Honors. I hope that clarifies the seeming misunderstanding with respect to our position on complementarity, Your Honors.
All right, thank you, Counsel. Chief, thank you.
No more. I can use you want? Or just
Mr. Counsel, part of foreign policy determination by the executive is the designation of ambassadors, correct?
That's correct, Your Honors.
If the President decides to appoint an ambassador to another country, it requires the confirmation of the Commission on Appointments.
Yes, Your Honors.
Composed of the representatives of the upper and lower house. Is that correct?
That's correct, Your Honor.
Now, if the President decides to recall that ambassador, will it require the confirmation of the Commission on Appointments?
No, Your Honor.
Okay. There was a unilateral act of the President, correct?
Yes, Your Honor.
And that will not be unconstitutional.
That's because that pertains, Your Honor, as already explained, Your Honor. That's really the
Part of
the alter ego powers of the President
correct,
to appoint someone who
part of
represents him.
foreign policy determination by the President, correct?
Yes, Your Honor.
Let's reverse the situation. Another state sends an ambassador to the Philippines. To whom would the credentials be presented?
To the home country, Your Honor.
To the to the foreign
To
ambassador.
the receiving country, rather, Your Honor.
Who in the receiving country, like the Philippines, would accept the credential?
It's the head of state of
The
that country.
President.
Yes, Your Honor.
Okay. Can the Senate tell the President, we don't like that ambassador?
The Senate of that country, no, Your Honor. It's really the executive, Your Honor, that
So in
the
other words,
receiving powers.
there
Your
are
Honor.
instances with respect to foreign policy that the President can act unilaterally.
Yes, Your Honor, we agree with respect to that question.
Without the participation of either houses of Congress, is that correct?
That's correct, Your Honor.
Okay, thank you.
Just a few short questions. You mentioned that case. What was that case? Katanga?
Katanga and
What
Bemba.
country was that?
That's in Congo, Your Honor.
In?
Congo.
Congo.
Yes, Your Honor.
And in Congo, it was self-referral by Congo, right?
Yes, Your Honor.
So
that's correct.
complementarity was not a question.
That's also part of complementarity, Your
Because
Honor.
it was not it was the country itself which said that it wanted jurisdiction of the ICC, correct?
Yes, Your Honor. That's
No
complementarity, Your
further
Honor.
questions.
That's yes, Your Honor.
is the Rome Statute a self-executing treaty, or does it need legislation to implement it to become effective?
There's no need to implement it, no need for legislation to become effective. It's just a transformation by the Senate vote, Your Honor.
I'll read to you a portion of your petition pertaining to the decision in South Africa, where the court struck down the unilateral withdrawal of that country to the Roman Statute. This portion, I'm going to quote from your
Yes, Your Honor.
from your petition. It says here, but this, so referring to the unilateral withdrawal, ignores the effect of the Implementation Act. It is a domestic legislation which creates peremptory obligation which bind the state on their own terms, independent of its international obligations. In other words, South Africa's international obligations are thus not dependent on the Rome Statute and vice versa, which means that the decision of the court in South Africa was based on a domestic legislation, and that was the Implementation Act.
That's correct, Your Honor. In our case, Your Honor, it's the resolution, Senate 546, that transformed the Rome Statute into Philippine law, Your Honor. So that is the equivalent, Your Honor, of the implementing act in South Africa, Your Honor.
So in our case, there's no such implementation act.
There's no need, Your Honor, because our jurisprudence says it becomes law by transformation. And that transformation happens when the Senate concurs in a treaty, Your Honor, with two-thirds vote, Your Honor.
So you're saying that the obligations of the Philippines under the Rome Statute would not need any implementing legislation? They can be put in effect on its own,
It becomes-
just based on the Rome Statute?
It became binding on us, Your Honor, by Senate concurrence.
But
That- all that-
there are so many provisions there imposing certain obligations on the Philippine government. Are you
That's correct, Your
saying
Honor.
there is no need for implementing guidelines coming from Congress to implement these provisions?
Yes, Your Honor,
of the
let me
Rome
clarify, Your
Statute?
Honor. With respect to the binding effect, Your Honor, that the Rome Statute became binding on us upon concurrence of the Senate. But of course, on pragmatic reasons, Your Honor, it's actually better to have implementing legislation such as what we have now, RA 9851, because it allows us to actually identify. Although in our jurisprudence, Your Honor, for instance, in Coroda, the court said there is no need, we can refer simply by incorporation. But even many experts would say, Your Honor, that implementing legislation is still desirable. Although, as I said, Your Honor, the implementing legislation is not required for the Rome Statute to become binding on us because it became binding upon the concurrence of the Senate.
I ask this question because your petition relies heavily on the decision of the South African court. Can you provide us with a copy of this Implementation Act
Yes, Your Honor, we will
to
do
guide
that.
us so that we can see why there was a need to pass an Implementation Act in the case of South Africa? And you're saying now there's no need for us to do that. What are provided for in the Implementation Act?
Okay,
Why was
very
it
well, Your Honor.
needed? Why was it needed in South Africa? And you're saying it's not needed insofar as the Philippines is concerned. So it's
Yes, Your Honor, thank you. We will do that, Your Honor.
Yes. Now, the withdrawal from the Rome Statute was done in accordance with the provisions of the Rome Statute.
Yes, Your Honor, Article
So it did not
165.
repeal the statute, or it did not set aside the statute, because this is provided for in the statute itself.
That's correct, Your Honor. It's part of the procedures outlined in the Rome Statute, Your Honor.
Now, earlier, it has been conceded by you that there's no textual basis to say that the Senate should also concur with the withdrawal. Now,
No express provision,
so you
Your Honor.
are relying mostly on, based on your petition, on the irrationality of the process followed when it is only the president that withdraws.
It's
from-
one of the grounds, Your Honor. A second
Yes,
ground.
but there's no textual basis for that. So
There's
you're
no
just
express textual
citing the
basis.
irrationality.
That's correct, Your Honor.
Now, will it be proper to look deeper into the legal consequence of entering into a treaty as distinguished from withdrawing from a treaty, insofar as these two acts would involve or affect the substantive constitutional prerogative of the executive and the legislative branches of government?
That is why it should be submitted to the Senate. The idea, Your Honor, is precisely for the withdrawal.
I'm not referring to the process. As I said, you discussed the irrationality of the process of not complying with the same process of concurrence to a treaty and the withdrawal. But it's, as Justice Hardelesa mentioned,
Yes, Your Honor.
you cannot find any language in the Constitution that would justify that interpretation.
We agree, Your Honor.
Now, but we know from jurisprudence that the President can enter into executive agreement on his own without Senate concurrence or ratification. Now, what is the basis for this difference, notwithstanding that under the Constitution now as written would cover all agreements must be entered into by the President with the concurrence of the Senate. But jurisprudence still admits that the President can enter into international agreements without the concurrence of the Senate.
That's with
And
respect to executive
so-
agreements, Your Honor.
No, let me finish.
Yes,
So
Your
why is that so? what is the basis for this interpretation of in the decisions of the court that the President can do that? As mentioned by Justice Alex Esmundo earlier, there are certain acts which the President can do on his own. Even if an ambassador's appointment is concurred in by the Commission on Appointments, still the President can withdraw that appointment on his own only. So there are certain acts that the President can do, even if initially it is a joint authority given to the President and to Congress. So there must be some reason behind it.
That's
so
correct,
that's what we want to look into. Why would withdrawal be different from entering into a treaty? When you enter into a treaty, the government assumes so many obligations under a treaty. But when you withdraw from a treaty, then the government is relieved of a lot of responsibilities arising from the treaty. Is that material insofar as insofar as taking into making that decision why there may be a difference between entering into a treaty and withdrawing from a treaty? So I'm not making any conclusion.
Yes,
I
Your
want
Honor.
you to look into that.
In our memorandum,
Because
Your Honor,
we cannot find any basis from the language of the Constitution. So we're trying to understand this. We want to find the rational basis, not only the rationality of the process, but more important is the rationality in substance. What is the implication on the exercise of the power of the executive as distinguished from the powers of the legislative department? So that's all that I'd like to impart.
yes, Your Honor, we will do that, Your Honor, in our memorandum.
So I have no more question. Any other question from the court? Okay, so we are done with the arguments of the petitioner in case number, what's that? Excuse me. In case number 239483. Now, with respect to the other case, which was filed by the senators, we note the manifestation of Attorney Anne-Marie Coronamines, who entered her special appearance for the petitioners in the other case. Do I get this correctly, Attorney Coronamines, that the senators are still considering the position that it will take in view of the denial of the motions regarding the participation of Senator Laila de Lima in this case? So that is your manifestation. So we note your manifestation, and we will set the continuation of the oral arguments on Tuesday, next Tuesday at 2 o'clock in the afternoon. That is September 4, and we will hear the respondents in the two cases. The senators, I said we note the manifestation that they are still considering what position that they will take. So that will depend on your submission. We hope you can do that before Tuesday, whether they would like to still participate in the oral arguments on Tuesday. Yes.
Thank you so much, Your Honor. Yes, I will relay this to the senator petitioners, and they will decide before Tuesday. Thank you.
Will you be able to inform us before Tuesday?
Yes,
on Monday?
yes, Your Honor. Yes, Your Honor, we will.
Okay. Not later than Monday?
Yes.
So that the court can plan for the oral arguments on Tuesday afternoon.
Thank you so much, Your Honors. Thank you.
So for lack of material time, the continuation of the oral argument is hereby set for Tuesday, September 4 at 2 o'clock in the afternoon. Adjourn the session. Attorney Aricheta.
All please rise. please remain standing while the Chief Justice and the Associate Justices leave the session hall.